York State Bar Association, Cheryl Levine Wallace. Justice of the Appellate Division, First Department, Justice Diane Renwick. Presiding Justice of the Appellate Division, Second Department, Justice Hector LaSalle. Presiding Justice of the Appellate Division, Third Department, Justice Elizabeth Gary. Presiding Justice of the Appellate Division, Fourth Department, Justice Gerald Whalen. The Chief Administrative Judge of New York State Unified Court System, Judge Lawrence Morris. And the Acting Chief Judge of the State of New York, Judge Anthony Cantero. The hearing will now begin.
Good afternoon, everyone. Please be seated. Good afternoon and welcome to our Civil Legal Services hearing for 2022. It is an honor and a privilege for me, as the Acting Chief Judge of the Court of Appeals and the State of New York, to welcome you to this, our 2022 public hearing on civil legal services. These hearings have been mandatory viewing for me in my past role as an administrator of a high-volume needs-of-life court in New York City, and I even had the privilege of testifying at these hearings in 2020, so it is a special honor for me to preside over today's proceedings. Joining me in the courtroom today are leaders of the judiciary and the bar in New York. Starting on my far right, the Chief Administrative Judge of the Courts, Lawrence K. Marks. From the Appellate Division, First Department, we have Associate Justice Diane Renwick to my immediate right, who's representing Presiding Justice Rolando Acosta, who was unable to join us today. And in the middle, we have the Presiding Justice of the Appellate Division, Third Department, Elizabeth Gary. To my left, starting to my immediate left, we have the Presiding Justice of the Appellate Division, Second Department, Hector LaSalle. The Presiding Justice of the Appellate Division, Fourth Department, Gerald J. Whalen, and the President of the New York State Bar Association, Sherry Levin Wallach, who leads the largest voluntary statewide bar association in the country with over 70,000 members. I want to thank each of these leaders for their presence and participation today, and for their joint commitment to maintaining a civil justice system that is accessible to all New Yorkers, regardless of income, background, or special needs. I also want to recognize the chair of the Permanent Commission on Access to Justice, Helene Barnett. Her wise and devoted leadership of the commission since its formation in 2010 is one of the reasons that New York State has become a national model for the effective delivery of civil legal services. Thank you, Ms. Barnett. And thank you to the dedicated members of the Permanent Commission who have worked tirelessly across the years to help ensure access to civil justice for people of modest means. One of the commissioners, once again present here today, Deputy Chief Administrative Judge Edwina Mendelson, deserves to be recognized for her leadership of the court system's Office of Justice Initiatives, an office that works closely with the Permanent Commission and stakeholders across the state to ensure that our courts are accessible to court users of all backgrounds, incomes, and special needs. Thank you, Judge Mendelson. Thank you as well to Commission Member Camille Ciano-Enders, who I believe is joining us today, and for your dedication to New Yorkers in need. I am especially pleased to welcome our dear colleague, Judge Leslie Stein, and to commend her for her significant participation in this year's Law School Access to Justice Conference from her new home at Albany Law School, this year's virtual conference host. Judge Stein, thank you for your remarkable public service, your grace, and your commitment to access to justice. I would also like to recognize the presence of Justice Lucy Billings from the Supreme Court, New York County, who is a regular attendee at these hearings. And finally, I would be remiss if I did not recognize the Commission's outstanding support staff, including from the Office of Court Administration, Barbara Muley, Lauren Camphor, and Rochelle Klempner, and from the law firm of Sullivan and Cromwell, which provides invaluable pro bono support to this effort, Jessica Klein and Madeline Jenks. Thank you all. This is the 13th annual statewide public hearing on civil legal services in New York. The purpose of today's hearing is to hear from a broad range of knowledgeable and experienced presenters and the clients of legal service providers about the nature and extent of unmet civil legal needs for low-income New Yorkers and the challenges that need to be overcome to bridge the justice gap going forward. Also, the impact of free legal aid and assistance on the clients who are directly served, particularly in matters involving essentials of life, the broader economic and other benefits that accrue to our communities and to our state and local governments from expanding access to civil justice for people of modest means, and creative ideas and strategies for how we can move forward to bridge the access to justice gap in New York State. The oral presentations we will hear today, together with the written statements of interested individuals and organizations, combined with the Permanent Commission's year-round research and findings, will form the basis for the annual report to the Chief Judge, from the Chief Judge, which I will be submitting to Governor Kathy Hochul and the New York State Legislature on or before December 1st, as required by a joint resolution of the New York State Legislature adopted in 2010. The Chief Judge's report will summarize the state of access to civil justice in New York State, including the progress that has been made to narrow the access to justice gap, the different obstacles and challenges that we need to address to continue making progress, and our carefully considered recommendations for the level of monetary resources necessary to address the state's unmet civil legal needs and promising and creative non-monetary strategies and solutions designed to increase access to justice. For the past 12 years, under the leadership of Chief Judge Jonathan Lippman and Chief Judge Janet DiFiore, these public hearings have been a driving force behind the significant progress we have made in collaboration with our stakeholders and justice partners and the steadfast support of our partners in the executive and legislative branches to expand the availability of free legal aid and representation to low-income New Yorkers. Not only does New York lead the nation in judiciary funding for civil legal services, a funding level that was increased from $100 million to $112.6 million in the last fiscal year to address rising expenses and a surge in pandemic-related legal needs, but our state has also become a model for how to leverage collaboration, innovation, and technology to achieve an effective and efficient statewide justice delivery system. We owe a debt of gratitude to the two remarkable leaders who have put us on this positive trajectory. Chief Judge Jonathan Lippman for his extraordinary vision and foresight in establishing these public hearings and the Permanent Commission on Access to Justice, and Chief Judge Janet DiFiore for wholeheartedly embracing these public hearings and significantly advancing the cause of equal justice in our state. Now, turning to this year's public hearing, we are fortunate to have an excellent group of legal, judicial, business, and healthcare leaders who will help us focus on the unmet civil legal needs of low-income New Yorkers at this moment in time when so many individuals and families continue to struggle with the fallout of the COVID-19 pandemic, including serious legal problems involving housing, healthcare, consumer and medical debt, domestic violence, family stability, education, and so many more. We are grateful to these knowledgeable presenters for their insightful perspectives on how we can ensure access to justice for low-income New Yorkers in matters involving the essentials of life. During this year's hearings, we will once again hear from clients who have received the help and assistance of legal service lawyers, and we very much appreciate their courage in coming forward to tell their stories so that we can better understand how access to free legal aid and assistance affects the lives of individuals and families and the well-being of our communities. For 3.5 years, I had the privilege of serving as the administrative judge of the New York City Civil Court, which includes the New York City Housing Court, a court with a very large population of indigent and unrepresented litigants, and one that typified the daunting operational, administrative, and policy challenges involved in delivering legal services to communities in need. And so you won't be surprised to hear that I have a very strong interest in the issues and challenges under consideration today, or that I am truly honored and excited to have this opportunity now as acting Chief Judge to be part of this incredible effort to expand access to civil justice for all New Yorkers. And now, without further ado, let us proceed with the 2022 public hearing on civil legal services. Before I call our first presenter, I do want to briefly address a few housekeeping matters to ensure that the hearing proceeds smoothly. We have asked each presenter to limit the length of their remarks so as to be respectful of everyone's time today. To aid in that, we use a system of lights in the courtroom, white to signify that there are 2 minutes left and red to indicate that the time for remarks has expired. For those appearing remotely who may not be able to see the lights, I may let you know that your time is about to expire and that you should bring your remarks to a conclusion. Thank you for your cooperation. Our first presenter today is Deborah Enox Ross, President of the American Bar Association, the world's largest voluntary association of lawyers. Ms. Enox Ross is professionally employed as a senior advisor to the International Dispute Resolution Group at the law firm of Debevoise and Plimpton, and she has enjoyed a highly distinguished career in the field of alternative dispute resolution. Ms. Enox Ross will provide a national perspective on the dimensions of the access to justice gap and how the pandemic has intensified the legal problems of financially disadvantaged Americans. Thank you, Ms. Enox Ross, for appearing remotely, I believe all the way from Edinburgh today. We look forward to your presentation. Ms. Enox Ross, if you're unmuted, we're ready to hear from you.
Yes, thank you. Can you hear me?
Yes, we can.
Oh, wonderful. Thank you very much. So good afternoon. I am Deborah Enox Ross, President of the American Bar Association, and it is certainly my honor to speak at this hearing on civil legal services in New York. So let me start by first thanking the Acting Chief Judge Kanataro and the other esteemed members of this panel for your interest in this really important topic, along with Chair Barnett of the New York State Permanent Commission on Access to Justice, for inviting me to present remarks today. I also want to acknowledge the participation in this hearing of my counterpart, New York State Bar Association President Sherry Levin-Wallach, as the ABA certainly values our collaboration with state and local bar associations nationwide. So as a lawyer with Debevoise and Plimpton in New York City, and I was born and raised in Harlem and started my career as a legal aid lawyer in Manhattan, I have a clear interest in this area. But I want to devote my remarks not to my personal devotion, but also to my ABA's perspective as their national president. So as many of you know, the ABA is the largest voluntary association of lawyers and legal professions in the world. And our association has long understood that when one cannot obtain the assistance of counsel to resolve a civil legal problem, the result is often a denial of access to justice. Moreover, a lack of effective legal assistance frequently compounds the problem, multiplying adverse outcomes for the most vulnerable members of our communities, resulting in hardships for them and significant costs to society. So the key to avoiding these outcomes is through the availability of high quality, effective civil legal services for those in need, which can only be achieved with adequate funding and staffing. The ABA has several signature programs that support civil legal services, and enjoys the support of lawyers from across the country, including, of course, New York State. Our annual association-wide advocacy event called ABA Day in Washington mobilizes lawyers in part to tell their members of Congress how critical it is to robustly fund the Legal Services Corporation, which was created to financially support state-based legal aid organizations that help people with civil matters nationwide, especially at times like this when low-income Americans are still struggling in the wake of the COVID-19 pandemic as a result of natural disasters and in the midst of increasing inflation. The ABA also hosts the National Celebration of Pro Bono to showcase our profession's commitment to volunteer legal services. And the ABA also sponsors, along with the National Legal Aid and Defender Association, the annual Equal Justice Conference for legal professionals who provide a range of legal services for the poor. The ABA's Standing Committee on Pro Bono and Public Service administers Free Legal Answers, which is an online advice clinic through which attorneys provide pro bono civil legal advice to income qualified users. And in the 7 years since launching ABA Free Legal Answers, almost 11,000 volunteer attorneys have signed up to answer nearly 250,000 civil legal questions. Currently, 40 jurisdictions, and I'm proud to say including New York, are live for client access, and an additional 2 jurisdictions have committed to participate. The ABA has also long advocated for and supported the establishment of state access to justice commissions like the New York's Commission to expand access to civil justice at all levels for low-income and disadvantaged people. The ABA Resource Center for Access to Justice Initiatives maintains a library of resources. We convene Access to Justice Commission members and other stakeholders, and we host a racial justice working group, which is composed of leaders from Access to Justice commissions from around the country, including, again, the New York State Permanent Commission on Access to Justice. The ABA's Standing Committee on Legal Aid and Indigent Defense, known by its acronym of SCLAID, helps to define ABA's access to justice advocacy. SCLAID collects and analyzes legal aid funding data in its ABA Array Legal Aid Funding Report and uses its findings to underscore the dire need for substantially increased funding. For example, SCLAID used data found in the Supporting Justice report issued by the ABA Standing Committee on Pro Bono and Public Service, as well as data from the National Bureau of Labor Statistics to determine the average cost for representation in a typical civil legal aid matter, and then compared it to the overall funding available for civil legal aid. The eye-opening result of this analysis is that for each low-income household experiencing a civil legal problem in 2021, the average cost of legal services to resolve the issue was $3,065, but the overall available legal aid funding for all sources nationwide was only $175 per low-income household. So it is clear from this data and other sources that our nation is not even remotely close to adequately funding civil legal services for those in need. The global pandemic has exacerbated the problem, significantly affecting low-income individuals and families. The extent and degree of legal problems created by the pandemic for the most vulnerable in our society is sobering. 33% of low-income Americans experienced at least one civil legal problem linked to the pandemic in the past year. But overall, 92% of those with civil legal problems did not receive adequate or indeed any legal help for their problems. The pandemic has unquestionably intensified an already profound justice gap in this country. An unfair advantage may arise when one party has the financial means to retain counsel while the other does not, which often occurs during landlord-tenant disputes, employment cases, and healthcare matters. The National Center for State Courts conducted a study which found that the representational imbalance among plaintiffs and defendants has dramatically worsened over the last 2 decades. When determining funding, states should consider the increased number of underrepresented litigants in civil courts resulting from both inadequate funding for legal aid and a large poverty population. The United States of America promises every citizen that the rule of law will be applied impartially and equally regardless of circumstance, national origin, gender, skin color, creed, or wealth. But our civil justice system is simply not designed for those without legal help. The law, as we know, is a complex combination of technical terms and procedures that can be exceedingly difficult for the average person to understand. Help from a legal professional is a necessity for even seemingly routine matters, but millions of Americans lack the resources to afford counsel as they seek to protect their most basic and fundamental rights. So as the demand for civil legal services throughout the nation continues to rise, only a robust increase in federal, state, and local funding for such services can begin to close the growing gulf between those who can afford legal representation to help resolve their problems and those who cannot. I appreciate this panel and what you're doing to evaluate and address the unmet civil legal needs of people in New York. And again, I thank you for this opportunity to share the ABA's views.
Thank you, Ms. Enix-Ross. We're going to open it up to questions now. So let me begin by asking you, you mentioned that you got your start as a legal aid attorney in Manhattan. And now as president of the ABA, you're in a unique position to gauge progress that's been made over the course of your career, both locally and nationwide. So let me ask you, do you believe that we've made progress either here in New York or as a nation to expand access to justice? And what do you see as the single greatest obstacle right now to ensuring equal access to justice for all Americans?
Thank you for that question. And yes, I started out at MFY Legal Services in New York. And certainly, I would say that there has been some progress over these 40 years that I've been practicing, including a significant effort of lawyers, especially in New York, to provide pro bono legal services. And so from that perspective, there is progress. People certainly understand the need. And as I mentioned during my remarks, the ABA, during our ABA Day on the Hill efforts, we've seen significant understanding of the need to provide legal services and to provide funding. But the gap has grown, and part of it is because, as I mentioned, there are so many more people in need. And if you talk to, I'm sure, Legal Services Corporation representatives, they will talk about how there may be increases in funding, but those increases haven't kept up with the demand. So I think having hearings, bar associations in particular, encourage our members through our pro bono efforts to try and meet some of that need is important.
Thank you. Questions for Ms. Enix Ross? Thank you very much for your time, and we deeply appreciate you coming to us from Scotland today, and we'll let you get on with what I'm sure are some very busy and important things you need to do.
Thank you again for this opportunity and for indulging me and allowing me to appear virtually, taking advantage of the technology. So thank you very much.
Thank you. Our next presenter today is Judge Meredith Vaca, an elected judge of the Monroe County Court since 2021. Judge Vaca serves as the presiding judge of the Monroe County, or served as the presiding judge of the Monroe County Special COVID Intervention Part, or SCIP, an innovative court model created during the pandemic to provide integrated on-site services to parties in eviction proceedings, including access to legal counsel prior to scheduled court appearances, emergency rent assistance, and other government and nonprofit services. Judge Vaca, thank you for joining us today, and we look forward to hearing about your experiences in the SCIP part.
Thank you. Good afternoon, Acting Chief Judge Canataro, Judge Marks, Justice Renwick, Justice LaSalle, Justice Gary, Justice Whalen, President Wallach, my fellow presenters, and all the other esteemed guests who have taken the time to watch today's hearing. To the Permanent Commission on Access to Justice, thank you for inviting me to speak, and of course for your ongoing efforts and dedication to delivering fairness and justice to all by improving access to civil legal services for the people of New York State. My name is Meredith Vaca. I am a Monroe County Court judge elected in November of 2020. I'm very proud to be here today to give a voice to my hometown, Rochester, in the 7th Judicial District in the 4th Department. As a county court judge, most of my work is in the criminal realm. However, my first few months starting out on the bench, I was asked to preside over our Monroe County Special COVID Intervention Part, also fondly referred to as SCIP. SCIP is a civil landlord-tenant court and was created in response to the pandemic and hardships on individuals and families facing eviction. In SCIP Court, I presided weekly over all our village and town landlord-tenant cases in one central location. Before SCIP, our local town and village justices would preside over these housing cases in their respective jurisdictions. As part of Monroe County SCIP Court, attorneys from local legal service providers came to court to provide free representation to the tenants who qualified. And honestly, I don't recall any tenant that didn't qualify for these services. So I'm here today to share with you my experience in SCIP Court, specifically as pertains to the legal representation provided to the tenants. And if I refer to SCIP in the past tense, it is because, except for one case, one remaining case, SCIP very recently ended. So our town and village court justices are back presiding over their eviction proceedings. But I'm very happy to reflect a little bit today with all of you regarding SCIP. My experience in SCIP Court involving an area of law I was unfamiliar with at the beginning was challenging and meaningful. There were significant stressors on both sides of the eviction proceedings for the tenants and the landlords. And the pandemic, of course, exacerbated everything. Many tenants could not pay rent or did not want to move for medical reasons. And many landlords, as a result, had great difficulties paying their mortgage. Understandably, tensions could at times be quite high in my courtroom. Nevertheless, my personal experience, and I believe the experiences of the litigants that came through SCIP, were made so much better by our outstanding attorneys who came to court every week to represent and advocate for the tenants facing eviction. I can tell you with confidence that SCIP Court would not have been nearly as efficient and effective without those attorneys. The attorneys who provided free legal representation to the tenants were from organizations that are part of the Tenant Defense Project, a program that provides free legal services to low-income residents of the Rochester area on housing matters, including Just Cause, Empire Justice Center, Legal Assistance of Western New York, and the Legal Aid Society of Rochester. My appreciation for them is immense. The landlord's attorneys were equally as great, and more importantly, they seemed to get along with each other, with a few exceptions, of course. Landlord-tenant law is not easy, and the special pandemic-related landlord-tenant laws and various moratoriums that changed over time were also complex. It is very difficult to imagine tenants being able to navigate all of this on their own without counsel. During much of my tenure over the skip court, tenants had the option of completing a hardship declaration, which would, for the most part, stay the eviction proceeding. At the time, at least in Rochester, there was this general public perception that a person couldn't be evicted no matter what. Therefore, it was vitally important for the tenants' attorneys to educate them about the hardship declaration and advise them on many other things, legal and practical. The Tenant Defense Project attorneys also educated their clients about the various rental assistance programs they could apply for. We had many tenants and landlords receive significant rental assistance payments, and many tenants applied for rental assistance right in the Hall of Justice. That's our main courthouse in Rochester, at the incentive and with the help of their attorney. So right in court, they were able to apply. Rental assistance, of course, benefited everyone, and I was always happy to see a case resolve in that way. We had a little under 1,600 cases go through SCIP, and only a small portion of those necessitated a hearing or trial. Most of the cases concluded with a settlement, and I certainly can't take credit for that. The tenants' attorneys were integral at helping come to a settlement for their client, advising them of all the parameters of the agreement, as well as the potential consequences if a condition was not met. And as judge, I could feel confident that both sides were advocated for zealously, concluding in a mutual agreement that both parties understood. Our court was in person but had a virtual option that many tenants and some petitioners' attorneys took advantage of. It was greatly beneficial to have the tenant's attorney present in the courtroom to represent their client and discuss various issues with opposing counsel and the court. Especially with COVID, there were many times tenants were unable to appear in court, whether virtually or in person. So having the tenant's attorney present to update the court on rental assistance applications or pending payments helped keep our docket running smoothly and sometimes helped protect a tenant from eviction. Very few tenants went through SCIP without taking advantage of the free legal representation that was offered to them. Without the option of free legal representation, I'm uncertain of how many tenants would hire their own attorneys, but my guess is that most would not, given their financial circumstances. I recognize that I was very fortunate to have good attorneys in my court to represent tenants. As I said earlier, I know that SCIP would not have run as smoothly as it did without them. I think the landlord's attorneys also appreciated the respondents' representation and the ability to directly correspond with another attorney regarding their cases. And most importantly, I am certain that the tenants significantly benefited from free legal representation, providing them knowledge and protection of their legal rights and a deeper understanding of their options in a stressful situation. For the felonies I preside over in criminal court, defendants, of course, have a constitutional right to counsel when facing serious charges and the loss of liberty. Tenants involved in eviction proceedings also face potentially serious consequences impacting their home, their lives, their partners' lives, and their children's lives. The ability to be represented by a knowledgeable and experienced attorney at no cost to them can be hugely beneficial, whether it be by avoiding eviction, gaining some more time to find a new place to live before being evicted, or settling on a payment plan. I am certain that we can all agree that it is better for a person who finds themselves facing eviction to be represented by a knowledgeable and experienced attorney to advocate on their behalf and counsel them than to be unrepresented, especially when most landlords are represented by attorneys. Accessible representation for the tenant is essential to basic principles of fairness and justice. Of course, I know there are so many other questions and obstacles in achieving that. I hope that sharing my personal experience in Monroe County Skip Court helped demonstrate the importance of access to free legal representation for tenants. Many thanks to all of you for listening and your commitment to justice for all.
Thank you,
you.
Judge Falco. I note that your skip part was in a densely populated urban area. And it allowed you to bring in the landlords, the tenants, and you could have the legal services there in the part, and you could connect, notwithstanding the fact that you mentioned that some tenants connected with lawyers even before they came to court, you could put them together right there in court. But there are many places out in the 7th that are more rural, and I'm wondering if you think the skip model could be replicated either in individual town and village courts, or maybe even creating regional skip parts in various places in the district, and whether you think that's a good model for delivering services in housing cases outside of New York City and other big urban centers.
I think it could, and actually, pre-COVID, the town of Arundecoy, which is one of the larger towns in Monroe County, had a program where people from Just Cause or Legal Aid came and represented the tenants. So I know that model is at least there. I also recognize that other than funding, getting attorneys to go out to these towns is one of the biggest obstacles, if not the biggest obstacle. I think figuring out the towns or villages that have the most landlord-tenant cases and starting there would be the most beneficial. For example, my colleague who is a Pittsford Town Court judge tells me that he does not get many landlord-tenant cases. But there are other towns, such as the town of Greece, where I grew up, that get a lot. And so I think finding those towns and starting there, I know the towns right now don't have virtual options, because we talked about that. I talked about that with the attorneys as Skip was ending, trying to kind of figure out what could be done. And I think having a virtual option would be helpful, since a lot of the towns and villages have court at night, and just getting the people there at 6 o'clock in the evening is hard. So virtual, maybe even recruiting new attorneys, new young attorneys that don't have families to go home to, and they can go out to court at night, and being assigned to certain courts, even if you started out with, some of the bigger towns, Henrietta, Arundecoy, and Greece, and worked from there. I think that could be helpful.
That answer was very helpful. Thank you.
Judge, if I could I, Chief? Judge, obviously the work you're doing is, or you did during the SCIF, was very important in the 7th. Kind of carrying on with the question that the acting chief just asked, there are certain towns that do have very busy dockets in town and village, dockets for landlord-tenant problems. And you do indicate that there's maybe the possibility of a program where we could have young lawyers who, in my experience, young lawyers are going out to those town and village courts anyway on a regular basis at night court. And so there might be a coordination ability there with the people that are going out and handling criminal cases on a regular basis to also maybe capture them while they're out there to have them handle some landlord-tenant. Are the calendars separated in your experience out in those town and village courts where they wouldn't be on the same night? And if so, is there some way that you can think that we might be able to overcome that?
So the calendars for the towns and villages vary depending on the town. So a lot of them are at night. Some of them are during the day, some are in the morning. They vary across the board. I think that your point is good about using people that are already there. So for example, you go out to Greasetown Court, there's a number of attorneys that consistently go out there, and using them, because they go out there, would be good. And then I'm thinking about the towns that are kind of further on the boundaries of Monroe County, the more rural towns. There are attorneys that go out there consistently and using them. So I think that's a great point, to try to use the people that are already there. Obviously, there's a assistant public defender that's assigned to each town. Usually they have, 2 or 3 towns they're assigned to, and they go there for every court appearance. As far as trying to make a more, I guess, regular schedule, I think that that's something that could be looked into, is trying to make a schedule that would make it more accessible for these attorneys to go out there. So if there was a virtual option, having all the landlord-tenant in a certain time where the attorney could appear virtually at a number of courts in the same time period. I think that would be efficient and would get more access to those towns.
Thank you, Judge.
If I may.
Go ahead, Judge Garrett.
Okay. Judge Vaca, and this may be unfair, you can tell me this is beyond your ken, but the town and village judges, and you've raised this possibility of them going virtual, they're not doing the virtual proceedings now. In your view, from knowing the judges to the extent you may and interacting with them, is it a failure of technology or experience and comfort with using the technology? In other words, should we make an effort to provide them with material, the tech to do the job, or would that be well received?
I think it would be well received. I think there's going to be someone out there, even if it wasn't maybe the judge himself or herself, that would deal with the technology. I certainly did not, my court clerk did, but I think there's going to be someone out there in the towns that could deal with the technology. And, I was talking about it with my colleague that I mentioned from Pittsford Town Court, and he's a young town court judge, certainly could deal with the technology, and I asked him, why isn't there virtual options out there? And he didn't really know. He just said, I don't know, it's just not an option for us. And so I think it makes sense to kind of head that way, not just for landlord-tenant, but for other reasons too. I can tell you, for landlord-tenant, and this is a bit of a digression, but being in person with a virtual option was so helpful to the tenants. There was, every court appearance, there were a number of tenants that appeared virtually because they couldn't come. During the pandemic, a lot of them didn't want to have to come down to the Hall of Justice. So I think giving virtual options to town and village courts would be beneficial for a number of reasons.
Thank you, Judge. Ms. Wallach?
Thank you, Judge. Judge Vaca, I'm building off the questions that have been asked of you already slightly. We're talking about resources in the town and villages in particular, and to some of the points that have been made, the idea of using already services that are already out there, attorneys that are already out there. The question I have for you is, do you have any thoughts on what resources would be needed in order to either provide expansion of those legal services from the bigger cities and towns into the rural courts, or what would be needed in order to expand potentially the purview of the legal service providers, both as Judge Whalen mentioned, the criminal justice providers as well as civil legal service providers, in order to bridge that gap?
Well, I think if we could bring in, let's say, the public defender's office, or have an assigned counsel program like we do in the criminal realm, and so the criminal defense attorneys that go out there, bring them in as a resource, that's a possibility. It seems to me that if they're going to be going out to these towns and village courts anyway for their criminal cases, they may be willing to take on some landlord-tenant cases too, if there was funding there. I know that there was some funding, because even though I presided in the Hall of Justice in the city, I was handling the town and village cases. And so our city court judges were handling all the housing matters that occurred within the city. And so I guess in this post-COVID world, the city court judges have those attorneys there. So the people from Just Cause are still coming to the Hall of Justice. I think probably because there's more landlord-tenant cases, and it's a central location where they can all go to. So I know that there's still funding there. Obviously, we would need to extend it to the towns and villages, but it is a very good thing now that even in this post-COVID world, all of the our city court landlord-tenant cases, they do have attorneys from Just Cause and other, agencies from the Tenant Defense Project to come there and help them. And there are still people getting rental assistance even now. I hope that answered your question.
Thank you.
Thank you, Judge Vaca. We
Thank you.
appreciate your time.
Thank you, everyone.
Our next presenter, David F. Levine, is the Chief Legal Officer of Bloomberg LP, where he oversees the company's global legal and compliance functions. Mr. Levine leads Bloomberg's award-winning pro bono program, which provides over 5,000 hours of free legal services to a broad range of low-income individuals and small businesses. Mr. Levine serves as a member of the New York State Business Council on Access to Justice, established in 2020 by Chief Judge DiFiore, to foster greater collaboration with the business sector. He will speak to us today about Bloomberg LLP's and the business community's support for civil legal services. Mr. Levine, thank you so much for being with us today.
Justices Renwick, LaSalle, Gary, Whalen, and Marks, and to President Wallach of the New York State Bar Association for convening this very important conversation to evaluate the unmet civil legal needs of low-income New Yorkers. I'm honored that Helene Barnett and the Permanent Commission on Access to Justice asked me to share my perspective on the importance of civil legal services. You'll hear today from clients whose lives have been forever improved by this work. My written submission contains one of many examples of clients we have helped by partnering with legal services organizations. There are many reasons to support this critical work. We don't often focus on the benefit to the business community. One critical cornerstone of a free society is a robust set of laws that protect the most vulnerable. For these protections to be impactful, everyone must have quality legal representation and access to the courts. New York is an attractive destination for immigrants from all over the world and this country because we are a state of opportunity and fairness. The outstanding diverse talent we attract is a major driver of success for New York businesses. Thriving small businesses are also critical to growth. Whether or not individuals moving to New York need free legal services, their availability benefits all in a stable, fair society. Bloomberg's Legal and Compliance Department started our pro bono program in 2016. Our annual global participation rate in the program is close to 100%. The department staff has contributed nearly 25,000 hours of time, expertise, and unique skills in meaningful ways to help underserved communities. We are firm believers that helping those in need is a fundamental obligation of legal professionals. And our commitment to pro bono work is firmly established in Bloomberg's culture, where our values of philanthropy and service stem from our founders' personal commitment to giving back. While we are proud of the scale of and participation in our program, we measure our success in lives permanently changed for the better. We've helped individuals obtain asylum, veterans receive the benefits they deserve, low-income victims of domestic abuse obtain divorces and protection, and transgender individuals change their names. You can learn more about the depth of our program and the many wonderful organizations we work with in our written submission. In close partnership with Bloomberg's corporate philanthropy team, we've built strong relationships with organizations committed to service. We specifically developed our pro bono program to work with our partners to address the legal, mentoring, and other needs of local communities. Our partners include not-for-profits, law firms, and other corporate legal departments, including those of our clients. In addition, as a member of the Business Council for Access to Justice, our pro bono program has been able to further expand our offerings in collaboration with the programs of other member organizations. From our initial conversations with legal services providers, we identified 3 initial clinic programs to offer to our team: helping veterans with disability benefits, assisting small business owners with a range of legal issues, and supporting green card holders with applications to apply for U.S. citizenship. We quickly realized that it would be critical to work with legal services providers that could provide the programmatic structure and supervisory support necessary to ensure our team to deliver timely, high-impact legal assistance to those who need it most. None of these projects get off the ground without the dedicated leaders and teams of the organizations in the legal services community. Let me illustrate this by discussing just 2 of the many nonprofit legal services organizations in New York that our department does a lot of pro bono volunteer work with: City Bar Justice Center and Legal Services NYC. Since 2018, our attorneys have volunteered over 1,000 hours with Ellis NYC, working on citizenship naturalization and visa applications for immigrant and LGBTQ+ asylum seekers, transgender name change petitions, public benefits and emergency rental assistance, and VAWA self-petition clinics for immigrant survivors of domestic violence. Working with the City Bar Justice Center since 2018, our staff has contributed almost 2,000 hours on the Veterans Assistance Project, over 1,000 hours on the Neighborhood Entrepreneur Law Project, and hundreds of hours on immigration relief and small business legal advice. We are involved with 8 separate projects run by the City Bar Justice Center and 10 distinct programs run by Legal Services NYC. In April 2020, at the height of the COVID-19 pandemic, we quickly pivoted to the virtual environment, and our department contributed more than 5,100 pro bono service hours in 2020 alone to help close the justice gap for individuals and organizations. We partnered with the City Bar Justice Center on its small business clinic and expanded legal hotline project to assist New Yorkers by providing limited scope consultations to address COVID-19 related legal concerns, on top of our continued work with its existing pro bono projects. While we initially launched a pro bono program to enable our team to give back to our community and support the causes that are important to our employees, we realized quickly, much to our delight, that there are so many secondary benefits stemming from pro bono engagement, including developing skills and providing new experiences, such as transactional attorneys appearing in court. Of course, there are leadership and networking opportunities. It provides us all with a collective sense of purpose. Let me get back to today, though. Civil legal services funding remains critically important to provide and preserve the essentials of life for the most vulnerable among us. When our staff volunteers for City Bar Justice Center's legal hotline, it quickly becomes clear to them that the greatest need for civil legal services relates to housing, family, income maintenance, and consumer issues. And many of the callers they speak to are seniors, which makes sense since older adults are the fastest growing segment of New York State's population. From 2007 until 2017, the number of New Yorkers aged 65 and over increased 26%, while the state's overall population grew by just 3% during the same period. Today, there are 3.2 million New Yorkers ages 65 and older statewide. That is more than the entire population of 21 states. This growth in our state's senior population and increased poverty within that population shows the continued need for advice and counsel for those who are isolated and vulnerable. This all underscores the need for more holistic solutions to human and legal services needs, from increasing capacities in providing brief information and advice services to expanding public information and education efforts via Know Your Rights clinics and published resources, and partnering with local community organizations and elected officials to ensure that those in need of services know they exist and can access them. These are all areas in which the private bar and business community have the expertise and resources with which to assist. But sustained efforts like these cannot be deployed without stable, if not increased, funding for civil legal services so we can all continue to make a real difference in the lives of countless New Yorkers in need. Thank you for your careful consideration in this incredibly important matter.
Thank you, Mr. Levine. Mr. Levine, I don't know if you're aware, but we can't see you. You should feel free to turn your camera on if you're able to. And I'd also like to ask you, I was struck in reviewing your comments about how robust Bloomberg's pro bono effort is. There you are. Very good to see you.
Apologies for that. I'm sorry for the technical glitch.
That's okay. Bloomberg has put together a really impressive program, and I'm sure your efforts in that are no small part of that success. I'm wondering if you've ever considered if there are ways to export the model that you built at your company to other businesses that might be interested in developing similarly impactful programs. And even if you think maybe there could be a role for the Chief Judge's Business Council on access to justice to facilitate helping companies that are looking to increase their pro bono participation with doing that.
Yeah, thank you very much for the question. We are actively involved with other corporate legal departments. Obviously, the Business Council for Access to Justice is one avenue for us to do that. In addition, we participate in multiple forums with other in-house legal departments, and I've spoken on panels with other general counsels and chief legal officers, and we've been able to arrange efforts where we work together. And some of those efforts have been with our clients who also have very strong in-house corporate pro bono programs. And so I do think if we sort of look back through history, obviously a very large percentage of the sort of pro bono work done by the private bar has been done by law firms, which have greater scale and connections to perform that work. Over the last 5 to 10 years, I'm really proud of the efforts, not just of Bloomberg, but of many in-house legal departments to get more involved. And I will say that this sort of interest in-house in getting more involved has only amped up as a result of the pandemic and the greater need that we're seeing in our communities. I will also note that I think a lot of companies in increasing their ESG efforts and desires to sort of give back to communities have also enhanced their pro bono efforts. So I think we are really well positioned if we're able to combine our collective resources across these legal services organizations, across law firms, across corporate pro bono departments or corporate pro bono programs, and other organizations to meet the need. The funding piece obviously is important because a lot of our efforts are in conjunction with these legal services organizations. The need is unprecedented, and I cannot say enough wonderful things about the outstanding individuals who do this work every day and make it accessible to the rest of us.
Apropos of the last part of your answer, what has been your experience in convincing policymakers, governmental policymakers, that an investment in legal service providers is a net economic gain for the community as opposed to the follow-on costs from the lack of those services?
So for me personally, it is a new effort to be involved. I will say that I do serve on the board of directors of Legal Services NYC and of the New York City Bar Association, who are actively involved in those efforts, and I support them. This is the first time I've had an opportunity to publicly discuss the business case, to be candid, and it's something that I look forward to continuing to advance, both in the context of my being the chief legal officer of Bloomberg, but also in my involvement with these organizations.
Thank you. Questions for Mr. Levine? We appreciate your time. Thank you very much, Mr.
Thank you, and again, apologies for the video snafu.
Happy to see you.
Thank you.
Our next presenter will be Elizabeth Benjamin. Elizabeth R. Benjamin is the Vice President of Health Initiatives for the Community Service Society of New York, where she supervises health policy, health advocacy, and consumer health assistance programs that help over 100,000 New Yorkers to access affordable health care and health insurance each year. She's also co-founder of the Healthcare for All New York campaign, a statewide coalition of over 170 organizations dedicated to securing affordable, quality health care for all New Yorkers. Ms. Benjamin will speak to us today about the dimensions and the consequences of the medical debt crisis and the importance of providing legal aid and representation to low-income medical debtors. Thank you, Ms. Benjamin, for your appearance here today.
Thank you so much for having me. Can you hear and see me? I feel like that's a critical thing to ask.
Yes, we can both hear and see you.
Fantastic. Thank you so much, Your Honor. And to all the folks who are here and have expressed any interest in this topic today, it's a delight to be here and to return to this courtroom. I feel very sad that I'm not with you in person. I had hoped to be here, but I had to put my mother who's in Oregon in hospice over the weekend. And so I flew back, but I wasn't able to get to Albany from Eugene, Oregon. It's just too many complicated flights. So forgive me for not being in person. It is no reflection on how passionately I feel on this about this topic and access to civil legal services, having grown up both at Bronx Legal Services and the Legal Aid Society in prior lives, or past professional lives. So thank you for having me today. I now work at the Community Service Society of New York, which is an august New York institution. It's been around since 1843, and we're committed to improving the lives of low-income people of color, and we do it through direct services, policy research, and advocacy. Our health team annually helps over 130,000 New Yorkers each year. Our healthcare system, as you personally may have experienced, or if you have not, certainly your family members have, is Byzantine on a good day. It's hard to navigate. It, despite the best efforts of our beloved healthcare providers who care passionately about patient health, it's just hard to access care, hard to deal with medical billing, hard to deal with insurance. And that's where we come in. CSS, in partnership with 50 community-based organizations around the state of New York, run consumer assistance programs where we help people both enroll in coverage and kind of fight it out if they have a problem with an insurance company or a medical bill. And we do that in partnership with 50 community-based organizations and also through a live answer helpline. I'm delighted to say that we have a good critical mass of those community-based organizations are in fact legal services providers, and we are so grateful to have them as part of our network. We do provide services in all 62 counties of New York State. And collectively, since 2010, we've saved $140 million for New York's healthcare consumers, and we're very proud of that statistic. And we, have an incredible return on investment. If you want to get into any performance details, I'm the person to talk to. But recently, we've seen a tremendous spike in medical debt cases. In fact, a 64% increase over the last 2 years. Medical debt in America is pervasive. It affects many people. It does disproportionately affect low-income people and people of color. But basically, 58% of all consumer debt in America is medical debt. And it's, there's a lot of, empirical data about it out there, and it's all that's in my testimony, so I'll refer that to you. In New York, all this medical debt has real consequences for people. 70% of New Yorkers are very fearful that they cannot handle a major illness, should it come to that. 38% are avoiding getting care because they are worried about being able to afford it. And another 34% report having financial hardships because of their current debt burden. We decided to investigate this. That's what we do at CSS. And we did, in a very thorough way, we did compiled an exhaustive database of all medical debt cases brought in New York in civil court we looked by all 220 nonprofit hospitals in the state in every single county civil court. And what we found was that the nonprofit hospital system in New York had sued 53,000 people, over 53,000 people, for medical debt between 2015 and 2020. The reason why we focused on hospitals is by law, all hospitals are nonprofit charities, and there's real rules of the road about how they behave in medical debt circumstances, IRS rules and other rules, and they are not to take extraordinary collection practices such as suing someone, but they do. And they're not to do it unless they've evaluated someone for financial aid. Well, we looked at, a random sample of all these 53, thousands of court docket cases and, pulled a random sample in various counties. And this is what we found. We found that 112, not all hospitals sue patients, but about 112 do. 20 hospitals in 15 counties are really, disproportionately suing, are responsible for over 80% of all these cases. The amount they're suing for is just $1,900, which is almost nothing for a healthcare, for a hospital institution, but is life-threatening, really, economically, for a patient. All the hospitals were represented by counsel. 99% of patients were not. 98%, as a result, 98% of these cases were won on default, right? Patients don't go, they don't have lawyers, they can't go to court, they don't understand court, it's confusing. And, if that wasn't bad enough, people are being sued and they're getting judgments against them. These lawsuits, the hospitals have reported that they're taking over 2,200 liens a year on patients' primary residences. Just to be clear, 10 states in the country bar the practice of taking a consumer debt lien on a patient's primary resident. And then another thousands of other people are experiencing 10% gross wage garnishment. So let's just break that down. Say a low-income person makes $500 a week. That's for 20% of their gross wages is $50. Say their taxes is about half, $250. Then they're down to just $200 a week to pay rent, food, school supplies. You get the idea. It's an incredible burden on people. So, the other thing that we're sort of sad to report is as we pulled the case files, we saw that some hospitals are using sort of not the most highly regarded members of our bar. They're doing some suspect practices, kind of improper, I would say, service. Pleadings are not even noticed pleading. You'll often just see a 5-sentence pleading with a date and a alleged date of service and an amount, and that's it. So it's really, these cases are not the best of us, and certainly not the kind of litigation you would see in that room here. So, we have had some inroads legislatively. We've managed to change the statute of limitation for medical debts from 6 years to 3. We've changed the consumer judgment interest rate from commercial 9% to 2%. And then we have 2 bills that are pending the governor's signature. We hope she will sign them. One would bar the practice of medical providers taking liens on people's homes or garnishing their wages, and we're very hopeful that will get passed, and another one regulating a form of kind of resort fee called facility fees. And so we're hopeful that one will get signed as well. I'm going to close now. I just, of course, I come from a place, as many of you do, and maybe some don't, that I really, we really believe healthcare should be a human right. And this kind of practice of suing people for getting, medically necessary care is just kind of unheard of in basically every other country that's sort of our peer country, I would say, around the world. And, our patients need help. There are very few legal services, almost none. As you can see, we found less than 1% of folks were represented. When legal services did get involved, usually they weren't representing someone. They were drafting pleadings and having the patient go pro se. And it's really a desperate need out there. And I hope that this commission, in its wisdom, can help make, level the playing field for patients. We need your help. And I hope I'm, free to answer any questions you may have, or maybe you just want me to stop talking. That's okay too. Thank you very much again.
We're very happy to hear from you. I will say personally, I thought your statement was an eye-opener for me, especially that statistic that 58% of all consumer debt is actually medical debt. And that got me to thinking about the way consumer debt is handled in New York City, which is by aggregating all the consumer debt cases in consumer debt parts in our court of lower civil jurisdiction. And I also noticed that medical debt cases generally don't make it into our consumer debt part, which is unfortunate because there is an alarming lack of legal services for all debtor cases, but whatever services there are generally available on site in the consumer debt part. So I'm wondering if you think maybe structurally it would be good to change the way the courts handle consumer debt cases, by bringing medical debt in as a category of consumer debt, and centralizing them in a part, or at least in a part in those 15 counties that you mentioned where most of the cases are, so that whatever services are available can be delivered to the debtors.
I think that would be, it was shocking how difficult our work was to find this out, and it would be very helpful to have medical debt consolidated in one part. We tried to interview patients. It was really hard to track them down. We're literally physically pulling court files. I have to say that the court clerks weren't always enthusiastic to have, our law students come and ask for copies of the court files. And then other courts were great and would even PDF them and email them to us. But, it was a difficult time to be doing this research. So we don't know exactly what's happening in these parts. I think having judges that know, for example, that our state law requires every single hospital to have a financial aid policy, and that should be part of the pleadings, that this individual patient, and our financial aid policy under state law is very generous. It goes up to 300% of the federal poverty line. I think it could be more generous, but even so, it's more generous than some other states. And in exchange for having hospital financial aid laws that require all hospitals to offer it up to 300% of poverty, the hospitals, it's not like they're getting this for free. They get $1 billion a year to incentivize them to provide this. But we never found, believe me, we looked at thousands of court files. We found only one case where a legal services person had drafted a pleading saying this person had applied for financial aid, but that was the only case. Thousands of cases we reviewed where no hospital a lawyer ever alleged that someone was evaluated for hospital financial aid. If you had a medical debt part, that presumably those judges, and we would be happy to, train them on the state law, could ask pointed questions on behalf of the patients who really don't know how to defend themselves in these cases, and as a result, just don't go at all.
Thank you.
Judge, I have a question.
Ms. Weller?
Thank you, Judge. Ms. Benjamin, eye-opening. I am in the same position. My eyes have been widened to this need, and my question for you is, do you see any access to pro bono legal services or pro bono legal service programs that would cover representing clients in this space? And if not, what we can do to create more access for individuals to those services?
I think if we had a medical debt part, then a pro bono lawyer could come and, or staff that part. I think if we don't have that, patients, you can see they just don't go. So it's going to be hard to connect patients to pro bono, counsel, if you will. We are fortunately community health advocates. We're listed on the explanation of benefits. So we run the central, CSS, we're privileged to run the central live answer helpline that handles about a third of the 30,000 people that come to community health advocates every year. The rest is through community-based partners. And those folks were able to kind of catch them before they ever get sued. The problem is that these people are being sued for essentially their deductible. And I think having pro bono lawyers in these parts saying, hey, this person, the reason why they have a high deductible plan in this hospital, this rich hospital is suing them, is because they were never evaluated for financial aid in the first place. But I don't know how we can connect pro bono counsel if we can't if the patients don't even know they have the right to being to ask for financial aid or to be represented. I'm welcome to bring, sit down with anybody who has good ideas about how to connect that. I think that'd be amazing.
Thank you. Justice
And it would really help because I feel like some of these consumer debt firms really could use, some pointed questions leveled their way, let's say. Some opposition, it's just, right now it's just a mill.
I just want to ask a question. First of all, thank you so much for your very informative and enlightening comments on things I really wasn't aware of. And I hope that my question is not too granular in this particular area, but you've talked about the legislative inroads you're attempting, the policy research, and what you're trying to promote through the governor, et cetera. I'm just wondering, I was troubled by the fact that there are so many nonprofit hospitals who seem to be ignoring the IRS rules that already exist. And I wasn't really sure whether you were saying that there was a way or a need to augment pleadings to ensure that the rules to require greater specificity so that they are having to make these statements about whether they've checked on the financial assistance of each individual, or if they're already there, those pleading requirements and being ignored. And my other question, I'll just ask it now.
Okay. Wait, can I answer that one and then you ask the second one? Because I'm going to forget. Because I'm so excited about that one. I love that you asked that one. Thank you, Judge. So I want to say, first of all, California does it right. They say the burden of proof is on the hospital, but they have to say they're only suing someone who they've found is ineligible. We don't do that in New York. We have a bill before the legislature. We'll have to get a new bill number because it's a new legislative 2-year cycle that starts in January that would do just that. The other thing our bill would say, we're trying to amend the hospital financial aid law so that a CFO must sign off before a patient is sued. I mean, these are nonprofits. I mean, first of all, they just get $1 billion to support the provision of financial aid and their so-called uncompensated care. But beyond that, they get billions and billions of Medicaid funding. They get, no tax. They don't pay any tax, federal, state, city taxes. They have so much. There's so much. Rightfully so. I mean, I don't want to sound like I'm anti-hospital. We really believe in our hospitals. We want them to, they're nonprofit. We love and proud that they're nonprofits. We just think that this is I don't know. I think they've all lost their mind that these collection firms or someone have gone in and said, look, I have a way for you to get an extra couple of, dollars here, but it's the wrong way to do it. So, sorry. So yes, there is so much we could do legislatively to change the rules of engagement that would make it fairer for patients. But right now, that's not there.
Thank you. No need to be sorry. I appreciate your answer. Thank you very much. And I, too, support and appreciate hospitals and agree that we need them very, very much. I think we all agree there. The other question was whether or not, and having said how much I appreciate hospitals, whether or not there are avenues that are being pursued to ensure compliance by the 20 or so, I think you mentioned, nonprofit hospitals that are not seeming to comply.
So as I mentioned, I am a recovering legal services and legal aid lawyer. That's, so I'm feisty. You probably got that. What we've done at CSS, we've really sort of embraced this. And what we've done is we've selected, I would say, the top 10, I think we're up to 10 hospitals that were suing patients. And we have essentially made, I would say, they're not demand letters because we aren't litigating against them. We're not going to, we never say, oh, we're going to sue you, but we write them as if they're very, very lengthy 6-9 page letters that talk about, that do pull a random sampling of the cases that particular hospital has taken. We analyze the zip codes of the defendants and point out, and this is true in every single hospital we've analyzed, that they're disproportionately suing in zip codes that are high poverty zip codes, or actually also in the case of Albany County, high minority or majority minority in some case zip codes. And then we asked to sit down with them. We also analyzed their financial aid policy to see if it complies with state law. After years of advocacy, we got the state to have KPMG, the auditing firm, come in and analyze hospital financial aid policies, and unfortunately many fail. Every single year fail, different questions on it. That's been a long This has been a 20-year campaign on some level. I started it when I was at Legal Aid. And those conversations have been fairly helpful, I think. Some hospitals are unrepentant, but others have really said, we had no idea this was happening in our name. So H&H for Health and Hospitals, our New York City Public Hospital, was shocked to find that there had been 200 lawsuits brought in their name, and when we drew it to their attention, they discontinued them all. NYU Medical Center took over a medical center on Long Island. They had a very robust medical debt patient suing practice. And when we drew it to their attention, their general counsel said, give us a couple months, we're going to withdraw all these. And then other hospitals have stepped up to say, we're no longer going to take liens and wage garnishments, and done some other measures like that. And so, it's sort of our strategy is to write individual hospitals. Our strategy is to put out public reports. Our strategy is to, help people one by one. And then to draft laws that we think would help level the playing field. And I'm so excited to speak to members of the court, because if there's something we can do to make the court system work a little better, for example, the hospital collection firms say, oh, these primary liens are automatic. There's nothing we can do about it. And the way I understand it is they actually have to get a transcript of judgment, go pay a fee, and file the judgment with the court before a lien on a primary residence can occur. So is that automatic? It doesn't seem that automatic, but in any event, our bill would bar the practice totally, and we would be joining 10 other states. And I'm talking about not progressive states. I'm talking about Texas and, not Alabama. I mean, like places, I guess, that really prize home ownership, which I think we should also in New York. So I hope that was a helpful answer.
Yes, thank you.
So we're trying, we'll talk to anybody. We hope more will come forward. And many have stepped up, I have to say. But that doesn't mean that they can't, until we change the law, it doesn't mean they can't go back to these old ways. Once, we stop, it's a lot of work. And once we stop looking at all of this, it may come back.
Thank you very much.
Thank you. Judge Marks?
Just one quick question. Are a lot of these folks with medical debt, unpaid medical debt, Medicaid or for that matter, Medicare eligible?
Yes.
And,
Both Medicare and Medicaid eligible. In fact, this whole campaign started, we have a beautiful video with an older gentleman that had Charcot's, his name is John, and he basically spent the last 2 years of his life fighting medical bills from New York Presbyterian and just really lost that fight. We were never able to sort out all the bills because he was on Medicare, and they just kept coming. And one of our early bills had been to require hospitals to issue one consolidated bill instead of letting every single radiologist and surgeon and anesthetist and, bill people separately. That bill went down in flames. There was so much opposition. We've been too scared to bring it back. But, maybe after, revising the charity care law, the hospital financial assistance law, we could come back to that. I mean, medical billing is just so hard for people. But yes, Medicaid and Medicare.
But helping people navigate Medicaid and Medicare, does that necessarily require a lawyer? I mean,
It does not, and that's where Community Health Advocates comes in. We're listed on every Medicaid patient's notice of adverse determination. So if a health plan says no, then there are phone numbers on the back of it. The problem is a couple of places. People end up with bills before they are enrolled in Medicaid. Hospitals are very happy to help people enroll in Medicaid. Some people will not enroll in Medicaid. In Yates County, for example, there's a strong religious minority there that will not take government assistance. Other people are concerned for immigration purposes about enrolling in a public program. Of course, some immigrants are ineligible totally under federal law for Medicare. So it's a challenge. The hospitals are supposed to. There is a famous case called Mount Sinai versus Carnegie. They're supposed to evaluate people for Medicaid before suing them, and that is a legitimate defense to a medical debt case in New York State.
Thank you.
Ms. Benjamin, thank you so much for taking the time to testify. It was incredibly informative. And I hope your mother's settled in Oregon.
Yeah, I am so sorry. I really, really wanted to be there today. I'm a huge fan of legal services and of course this commission. So thank you so much for your interest in our work.
We understand. Thank you.
Bye.
Okay, we're going to take a short break now before we move on to the next phase of our program today. When we return, we will hear from clients of legal service providers, the first of whom will be Ms. Jenna McCormick. So we'll be back in just a few minutes. Thank you. Please be seated. As I mentioned before the break, we are moving on to what is in many ways the most powerful and impactful part of our program, which is where we hear from clients and their representatives about their experience with civil legal services. And our first client presenter this afternoon is Jenna McCormick, a client of the Empire Justice Center, and she is joined by Kristen Brown, the president and CEO of the Empire Justice Center. Ms. McCormick, thank you for joining us today, and we're ready for your testimony whenever you are. But we're very happy to have you here and to be able to hear you and hopefully see you, and you can begin whenever you like.
Okay, great. I'm just going to read a written testimony that I planned for the sake of my nerves and my memory. But big takeaway is I've had massive chronic pain for a long time. Insurance screwed me over, and I could not have gotten a procedure that was really, really helpful without the help of Empire Justice. So, all right, my name is Jenna McCormick. I'm 23 years old, and I'll be finishing my degree in social work in a few years. I love working with children with disabilities, and I know it will be my purpose in life. I also enjoy reading and spending time with my boyfriend of 4 years and our pets. Although my life might seem normal from the outside, I also spend a lot of my time dealing with my disabling chronic illnesses that cause severe pain and other symptoms that are difficult to live with. I have a condition called occipital neuralgia, which means the nerves at the back of my head are inflamed and cause near constant pain. I couldn't go to work or go to school for over 2 years because I was mostly bedbound. I went through this 2-year period of not being able to do anything because my insurance company denied the procedures my pain management doctor ordered. I first went through the appeal process on my own, overwhelmed by mountains of paperwork, making stressful calls to the insurance company, just hoping I was doing all the right things. I hoped that telling the truth about my dire situation would be enough to carry me through a Medicaid fair hearing. It was not. I had a telephone hearing due to the pandemic, and it was difficult to know who I was talking to and how they felt about what I was saying. Ultimately, I just had a clerk going over my appeal form and asking me if I wanted to add any comments. I was not asked many questions, so it didn't seem like a real hearing at all. There wasn't actually a judge on that call. It was weird. I waited several weeks for my results, and I was heartbroken but not surprised that the system had failed me again. I accepted this as my fate for a while before seeking help with Empire Justice, so I had received a denial from the appeal. I immediately felt so much more comfortable working with Empire Justice, and I felt so prepared for the second fair hearing. I worked with Alexia Michaels and Fiona Wolf, and they were fantastic about keeping me updated about what would happen next and what they needed from me. I felt such relief knowing that my case was in the hands of people who knew what they were doing. They knew what questions the judge would want answered and worked hard to get the evidence that supported our appeal. This time around, I still had a phone hearing, but there was definitely a judge, and Alexia was on the line with me. It went quickly, but we had prepared, and I answered questions confidently because I was simply sharing my life story, and I felt like I was telling the truth for the 100th time. Afterwards, Alexia called me, and we talked about how I felt about the hearing process. I felt confident, like we had laid out a solid case and I'd gotten to say everything I wanted to. And even though my attorneys couldn't guarantee me great odds at winning this particular case, I felt like we did the best we could on our end and we just had to wait and hope the judge ruled in our favor. Despite my confidence in our team at the hearing, I tried to prepare myself for disappointment because I had received so many denials from Medicaid in the past. I actually couldn't believe it when I read that the judge had ruled in my favor. I cried, my mom cried, everybody cried. This procedure could mean a world of difference for me. and it did. 9 months ago, I had what's called a radio frequency ablation performed at my pain management clinic. So after a long healing time from the procedure, I felt my pain reduced drastically. I was able to focus and target my other health issues and eventually tackle them well enough to start getting better overall. I was able to stand and walk with less pain and dizziness, build up muscle in my legs that had atrophied from my time in bed, and take my new dog for a walk, which I never thought I'd be strong enough to do when we first got him. I was even able to start working short part-time hours at a daycare to fulfill my love for children while I wait to finish my degree, and that's what I'm doing now still. I'm beyond thankful for having Empire Justice Center on my side for that hearing because I know they are the reason we were able to address the insurance company's points so directly and ultimately win our case. It literally changed my life, and I'm on a path now to a happy, productive life that I couldn't have imagined years ago when I was stuck in bed every day. Thank you.
Thank you, Ms. McCormick, and congratulations on getting the treatment that you needed.
Thank you.
I'm interested because fair hearings don't normally take place in court. They take place at agencies. How did you connect with the Empire Justice Center? Was that in itself a long process, or how did you know to even reach out to them?
I don't think there was anything particularly lengthy. I think I had talked to family and friends, and they were like, look at legal aid, because I couldn't afford anything on my own. So I think I had probably just kind of searched up on the internet, like legal aid near me kind of situation, and emailed a couple people. And, if I remember, they got back to me fast, and they were always super communicative about, okay, this is about how much time we should expect for this. Here's what I need you to do next. Here's when you should hear from me next. Just always very clear, and this is what's happening. So I appreciated that so much.
Appreciate that. Any questions for Ms. McCormick? Ms. Brown, congratulations on a successful fair hearing process. I don't know if there are comments you wanted to make?
Yes, thank you so much. Can you hear me?
Yes, we can.
Okay, great. So good afternoon. My name is Kristen Brown, and I'm president and CEO of Empire Justice Center. We're a statewide nonprofit law firm with an advocacy organization with 6 offices outside of New York City in Albany, Rochester, Yonkers, Central Islip, and White Plains. We have 2 offices in Rochester. We're an organization that seeks to focus on areas of law where we can have the most impact with the goal of addressing the root causes of injustice through a blend of direct services, targeted training, and systems change advocacy. I want to thank you all for the opportunity to speak today. We're deeply grateful for the ongoing commitment you have to civil legal services. And I want to note that the Judiciary Civil Legal Services funding is a critical revenue source for Empire Justice and for our peers, and also express particular gratitude for the multi-year compounded cost of living adjustment that we received last year. We all know that the cost of doing business rises every single year, and we're deeply grateful for your recognition of this with that funding allocation in the last state budget process. I also deeply appreciate Jenna McCormick for sharing her story with us today. Ms. McCormick was in many ways an ideal candidate for the fair hearing process. She was and remains motivated, accomplished, and highly capable. But as the first decision showed, that simply was not enough. And in order to get the medical care, she had to meet a burden of proof that she really didn't know existed. And it's clear from Ms. McCormick's case and many others, to succeed in this process, you have to have an understanding of how to apply evidence to meet a legal standard. Identifying and meeting a legal standard is not a patient's job. It's not a doctor's responsibility. That is what lawyers do. And after her first appeal was unsuccessful, Ms. McCormick was referred to us, and I can share with you that we connected with Ms. McCormick through the Community Service Society's Community Health Advocates Program, which you heard from Ms. Benjamin about earlier. And because of that, our lawyers were able to work with Ms. McCormick to build her case. Also work with her doctors, who were all along advocating for the treatment plan that Ms. McCormick was fighting to access. But once again, the doctor's orders were not enough. and clearly she needed a lawyer. Unfortunately, Ms. McCormick is not alone. According to the Office of Temporary and Disability Assistance, the agency that manages the fair hearing process that Ms. McCormick went through, in 2021 alone, there were 150,000 fair hearings requested. Data about the percentage of appellants that have representation is not available. It's not published, but based on advocates analysis, we are consistently able to determine that the vast majority of individuals are unrepresented at these hearings. There are many state agencies, including the Departments of Health, Labor, Education, that have fair hearing processes similar to the Office of Temporary and Disability Assistance. This is because the Due Process Clause of our Constitution, as well as federal and state laws, require that a person be afforded an opportunity for a hearing before their public benefits can be denied, reduced, or discontinued, which is important. Unfortunately, or fortunately, as it is, the fact is that the executive agencies are not part of the judiciary branch, but their decisions impact hundreds of thousands of New Yorkers' ability to access justice in the essentials of life and potentially in matters of life and death. Administrative hearings are intended to be navigable by individuals without an attorney, but as Ms. McCormick's story illustrates, all too often they just really are not. There's really little value to this right if pro se appellants can't effectively exercise. So ultimately, too many New Yorkers like Ms. McCormick are doomed to fail or be failed by this process because they do not have representation. Additionally, Ms. McCormick participated in the fair hearing process in the early, very chaotic days of the pandemic. However, many of the temporary measures that have been in place are still in place now, over 2 years later, and continue to present challenges. I want to note that to address some of these challenges, the Coalition of Legal Services Providers did submit a list of recommendations to improve the fair hearing process to the Office of Temporary and Disability Assistance and the Department of Health. Those recommendations included increased clarity of communications with appellants, transparency in data collection, and improving access for appellants whose primary language is not English. And a copy of that letter is available through the link in our written testimony. Clearly, our legal system is not confined to the judiciary, but our entire system must be examined for accessibility and fairness throughout. All of this underscores just how critical it is for New York to continue in its progress in closing the justice gap. Every client of a civil legal services provider is one more New Yorker who has a fair shot at accessing justice. Increasing judiciary civil legal services funding, including an annual cost of living adjustment to cover the cost of doing business, will provide thousands more New Yorkers with that fair shot and will allow us all to work together towards a more fair, equitable state for everyone. Thank you.
Thank you. Do you have any information concerning the numbers of appellants in these fair hearing appeals or any administrative appeals who are able to access legal services for their appeals?
Unfortunately, we don't have specific data about the number of people who are represented at this point in time. That's something that we would like to, we're advocating for, we'd like to see in the future. But what we find is that with, civil legal services providers, we do work with folks, we do represent them at fair hearings as much as possible, giving resources, but the vast majority do go unrepresented.
150,000 is a very large number.
It is a large number, and that's only for the Office of Temporary and Disability Assistance. So it doesn't, you can multiply that number exponentially over across all the different state agencies that have administrative proceedings.
Yes. Judge Gary?
Ms. Brown, Welcome, and thank you for your remarks. I just want to share with you, I just tried to link through to that letter because I'm curious to see it, and for whatever reason, it may be my technology, but I couldn't. It came up as unavailable to me. And so if you wouldn't mind, I'd like to see it if you could send it along to Ms. Barnett so that we could review. I'd appreciate that. Thank you.
Absolutely. I'm sorry about that. We'll get you a copy of the letter and we'll fix the link immediately.
Anything else for Ms. Brown? Ms. Micklin, I believe, Mickles, did you want to be heard? No.
Nope, I was just available in case there were any questions.
Very good.
Thank you.
Thank you. Thank you very much.
Thank you.
Thank you, Ms. McCormick. We'll move on to our next presenter, who is Barbara Robinson, a client of Legal Assistance of Western New York. Ms. Robinson received her legal assistance from Legal Assistance of Western New York, and she is joined by the executive director of that organization, C. Kenneth Perry. And we will now bring Mr. Perry and Ms. Robinson onto our screen. And we're ready for you to start your presentation whenever you'd like.
Okay. Well, my name is Barbara Robinson. I'm a former client of Western New York Law, Western New York Legal Assistance, and I became involved with them when I was sued for $21,000 by the Monroe County Nursing Home after helping a friend of my mom's, a dear friend of my mother's, supply Medicaid documentation, and I became power of attorney and her healthcare proxy, and I helped the liaison at Highland Hospital, where she was hospitalized, do all of her Medicaid application documents, including all of her financial statements. Mrs. Patterson was only at the nursing home for 2 months. The first month was actually covered by her supplemental Medicare insurance. At the time that I signed her admission papers, there was a piece of the admission that looked very sketchy to me. It looked like I was agreeing to be responsible, and they assured me that what I was agreeing to was to not stand in their way of receiving any of her funds, that because I had power of attorney, that I would agree that I would not in any way stop them from being paid. And of course I agreed to that. Mrs. Patterson and I both understood that going forward, her Social Security checks would go directly to them. I did sign the admission paper after that reassurance. I spoke to her social worker the day she was admitted. They told me everything was fine. And I said, now, do I start bringing her checks to you, to the financial office? And she said, you will not be getting any more checks. They will all now go directly here. And I gave notice at her apartment building. A cousin helped me clean out the apartment. We knew she was not going to be able to come home. I was at the nursing home all the time in the next two months prior to her death. I had conversations with nursing supervisors, with the social worker. No one ever said to me, you know, her bill's not being paid. No one ever asked for any information about it. Months after she had died, I suddenly got a bill for the estate of Janet Patterson and Barbara Robinson, and there was no estate. And since they had all of her financial records, I really kind of disregarded it. These people know there isn't an estate. Why would they even do this? But I was then sued by them for it, $21,000. I live on Social Security. I was 78 at the time. I had no income but Social Security, no way to hire a lawyer. I was really, I don't know, I think I was frightened, but I think I was also kind of despairing. I was kind of defeated that this is going to happen to me and I can't do anything. Friends suggested that I call for legal assistance. An attorney named Anna Anderson called me. I had already missed dates to file if I was going to put up any kind of a defense. Anna immediately contacted the attorneys that were suing me and got some time and began meeting with me, called me on the phone, met with me in person, went through all the documents. I was being accused of taking Mrs. Patterson's money and using it for my own use. And that really, I think that was one of the worst parts of it. And why I thought they couldn't do anything to me because they didn't have any money. It didn't seem to even slow them down. So Anna went over the laws. She told me that I was going to have to go to court. I explained to her what had happened. She kept with me every single step of the way. I had to go downtown Rochester and to the courtroom. She met me there. A couple of her colleagues were there, came into the courtroom with me, and the case was dismissed. Because I had lost, my power of attorney had ended. Had they called me, the day she died, I could have probably turned over records to them. I could have given them her current bank statement. But since my power of attorney had ended at her death, there was nothing I could do to put up any kind of information. I am very grateful. I would have had a $21,000 lien put against me, completely unjustly. The other part of it that's important to me. Over 80 years, I've been a client. I've paid attorneys for various things. I've been a paid client of different attorneys. There was no time during all of this process. I was treated with complete and total respect by law New York. I never felt I was less because I was not able to write them a check. I didn't feel I was unimportant. I was just something that they do. I called them and they were just I felt valued as a client, and I felt protected and safe. And I don't know. I really can't say more. I'm eternally grateful.
I appreciate your words, and I think your story is just a really striking example of the old adage that no good deed goes unpunished. And I am incredibly happy that you were able to connect with LAWNY, and I hope this doesn't discourage you from helping friends in need in the future, or anyone else for that matter. But I'm going to turn it over to Justice LaSalle from one of our downstate appeals courts who has a question for you.
All right.
Good afternoon, Ms. Robinson. I have to tell you, listening to your story and what you went through, it's striking, particularly because your story clearly demonstrates the importance of civil legal services for those who might not otherwise be able to obtain counsel. You said through your own words today, I think, something that I think many New Yorkers could relate to. You might not have even responded. You were just willing to accept this $21,000 lien because you didn't really have access. I'm personally struck by the plaintiffs in this matter for bringing an action and levying allegations absent what appears to be, at least from what we've heard today, very little evidence supporting it. Nonetheless, their bureaucracy, right? You walk in with your mother's friend. They need a name, right? That's all they know. You give them a name, and that's when your unfortunate journey begins. And it's striking to me that their bureaucratic issues cause you all this pain. So I really don't have a question, but I do want to just give my regards to you and the fact that you fought for yourself. You found Law New York, and you were able to get this literal monkey off your back. And again, I want to echo the statements of the Chief Judge by saying that I hope that this doesn't change anything about your benevolent nature, and I hope you'll continue to help your neighbors when needed, because you're a wonderful friend at a difficult time. So thank you for allowing me to make that statement to you today.
Thank you.
Thank you. Mr. Perry, I know you'd like to make a statement to our panel.
Thank you, Judge Canataro and other members of the judicial leadership team and President Wallach for giving me a few minutes to speak with you today. I am going to focus my brief remarks on the world of consumer law matters and consumer law issues that the legal services providers help low-income people with. I'd also like to thank Elaine Barnett for inviting me to speak with you today and for her many, many, many years of leadership on this important issue regarding the high unmet need for civil legal services for low-income people. And again, thank you to Ms. Robinson for being here today and for sharing your story with all of us. So my name is Ken Perry. I am the Executive Director of Law New York. And Ms. Robinson presented with regard to a particular type of consumer law matter, a collection matter involving nursing home debt. Not all of the legal services providers have the resources to handle consumer law matters. But for those who do, I wanted to present the many, many different types of consumer law issues that clients present with. I'm just going to recite a bunch of them here. We at Law New York at least work with consumers on car repossessions, bankruptcies, problems with aggressive creditors, inability to obtain loans or credit at reasonable interest rates, unpaid utility bills, problems with land sale contracts, which are rent-to-own homes, home improvement loan debt, wage garnishment, identity theft, credit report inaccuracies, problems with contractors, and then clients who are victims of a scam, and particularly in the past couple of years, victims of COVID-19 related scams. We are very, very proud of our consumer law unit. We established it here at Law New York. Law New York has been a program since 1968. Our consumer law unit was established recently, relatively recently in 2015, and in its inaugural year, The staffing for that project was paid for completely with the grant that we received through the Judiciary Civil Legal Services Program. Since its inception, our consumer unit has helped more than 2,000 people, and we've documented more than $1 million in savings to our clients. In my written comments, which there's not time to go through today, there's other examples of our work, including a story of a healthcare worker whose wages were being garnished in violation of the CARES Act by the Department of Education, and that client was referred. We did a warm referral to the National Consumer Law Center, and she then in turn became the lead plaintiff in an action challenging the Department of Education's wage garnishments of student loan debt during COVID. And that case, the outcome in that case impacted thousands of borrowers who were in financial crisis. In New York, just a metric on educational debt, there are presently today 2.8 million student loan borrowers. 10% of them, 280,000 people, are in arrears on their educational debt. The cumulative debt is just under $100 billion, and the average student loan debt is approximately $41,400. With all the COVID-19 protections, some of which are still in place, and with the new federal student loan forgiveness initiative, and with changes to the old public service loan forgiveness program, the need for advocates for New Yorkers who have educational debt is really, really important at this time. And nationally, you may be aware, the Legal Services Corporation in the spring of this year issued its latest Justice Gap Report, which is an assessment of the unmet need for civil legal services for low-income people across the country. The highest unmet need in this report was found to be in the area of consumer issues, with the finding that 50% of low-income Americans experienced at least one consumer law problem in the preceding year. And then it breaks these down into experiencing difficulties with medical debt, utility disconnections, aggressive creditor harassment, and falling victims to scams. So of course, consumer law is just one of the types of civil legal problems that our low-income communities come into our offices with. You know that there are issues with access to health care and government benefits and housing and family law and education and employment law. We are one of the providers that does provide services in all of those practice areas, but the high unmet need, the need for enhanced funding for civil legal services is really profound, and the hope is that there will be the ability for JCLS grantees to receive enhanced funding in the next state fiscal year. With regard to consumer, I'll just go back to that for one more minute. We serve 14 counties. We have over 200,000 people who are financially eligible for our services. In terms of attorney staffing, our consumer law unit has 4 attorneys to meet the needs of that population, and one of those positions right now is vacant, so functionally today it's 3 attorneys. Off topic, I did want to just briefly surface, I think I'm out of time, another issue that I'm hoping you'll be able to focus on at the judicial leadership levels, which is the rural attorney shortage. I am aware that another executive director was going to focus her comments today on that issue, Kristen Brown from Empire Justice Center. I don't know if she's already spoken with you or if she's following me. But with regard to that, back in the spring of 2020, the New York State Bar Association adopted a report and recommendations made by a rural justice task force that it had convened, and it confirms that there's a crisis with access to justice in the rural parts of New York State. It has findings, it has recommended solutions. One of the most striking findings was that of the attorneys practicing in New York State, 96% of them primarily practice in the urban centers in the state. Only 4% reported that they practice primarily in the rural counties in New York State. And the impact of the rural attorney shortage is real for Law New York. We received, so 13 of the 14 counties in our service area are considered to be rural. The exception is Monroe County, which has the city of Rochester. We received 2 very large grants, one from a federal agency, one from a state agency at the end of 2021 to allow us to significantly grow our project to provide services to tenants facing eviction. Through the 2 grants, we've received enough funding to grow our staff by 26 full-time attorneys to provide services to tenants facing eviction. Throughout the 14 counties in our service area. It's now September of 2022. We are 9 months in from the announcement of those awards. And to date, we've only been able to fill 7 of those positions. We just cannot hire attorneys to come to work for us in our rural offices. So I do recommend that the court's leadership work with the State Bar leadership to move the recommendations in that spring 2020 report into an implementation phase. So thank you for letting me speak with you today. Thank you for allowing Ms. Robinson to share her story. And thank you. I know clients of other civil legal services programs are with you today. I thank them. And thank you also to my colleagues from the other programs who will also be speaking with you.
Thank you, Mr. Perry. We did hear from Ms. Brown, and we also heard before the break from Elizabeth Benjamin, who gave us some very impactful testimony about consumer debt and specifically medical debt. And I have so many questions for you about that, which I'm going to save maybe for an offline opportunity. I'll give you a call. But the last thing you spoke about, hiring attorneys, and I understand that there are special concerns in rural areas in terms of finding attorneys who can provide services through your organizations. But this is actually headline news today concerning the inability to hire lawyers in the housing sphere, even in New York City. So it's a statewide issue. And I'm just wondering, and I think in your comments you said you have funding to hire 26 new attorneys, and so far you've only been able to fill 7 of those openings. What are your projections? What's your outlook for the hiring picture going forward? And when is this rapidly becoming critical problem going to ease up for legal service providers?
I don't know. It is disheartening. One of the issues for us, and we can talk about this for a long time, is our salary scales, which are just not competitive with, at least for Law New York at this point, not even competitive with other public sector employment opportunities or public interest employment opportunities that the attorneys that we tend to attract are interested in. We are pulling out all the stops in terms of figuring out our finances to move forward. We did do a slight revision to our salary scale at the beginning of 2022. We're going to try to move forward another one to take effect on October 1st and think that we can do a robust increase to the entry-level salary for attorneys, but it's only $52,000 now for a law graduate with no experience, and we're going to try to move it up effective October 1st to $58,000, which it may help, and then our salary scale has steps going up based on experiential credit through to level 30, so more attorneys with more experience, the salary may not be as off-putting as the dollar amount that we offer to people who are just recently graduating from law school, often with student debt, and many times with families and homes and just unable to accept the salary, a job at that salary level. And this issue for the providers outside of New York City, I think, is pretty consistent of our inability to pay what people deserve to do this work.
I wish you luck. I think Ms. Wallach has a question.
How did you know, Judge?
I could just sense it.
Thank you. And thank you so much, and thank you for referencing the State Bar report and for all the work that you do at the State Bar and in your work with Law in New York. And I also am very well aware of the issues with regard to legal services salaries, both legal service providers and public defenders. But I want to move away from that for one moment because I thought you spoke of it very eloquently, and speak or ask you a question with regard to trying to fill that gap in the rural areas. While we, as Judge Canataro mentions, clearly there is, we are all dealing with, across the state, a need for attorneys to fill positions and a lack of attorneys being willing to take the positions. Have you or do you consider, from the rural standpoint, that attorneys would be willing to potentially take a position, maybe working virtually, and if in fact they were able to do that, do you feel that your courts that you deal with and the other organizations that you deal with would be able to support that type of assistance? And do you think that would help, or do you think that it would not?
I think that it would help. I think that it's a potential remedy that most definitely should have brain power put to it and be explored. And I'd be happy to commit my program to doing that, and I believe that other legal services providers would as well. It is complicated because evictions are in town and village courts, and the state of I guess virtual proceedings can take place in town and village courts, but I think it's a heavy lift, and a lot of brain power and logistical work would have to be done for that to become successful. At my program, we would permit attorneys, right now our alternative work plan policy would permit them to work hybrid or completely remote after they pass their probationary period.
Thank you.
Any other questions for Mr. Perry? Thank you so much, Mr. Perry, and thank you, Ms. Robinson. It was an inspiring story, and I'm glad you were able to deliver it to us. We appreciate your time.
Thank you. Thank you to all. We appreciate you.
Okay, our next speaker will be Shane O'Brien, who is a client of the Center for Elder Law and Justice. Mr. O'Brien will be joined by Karen Nicholson, who is the CEO of the Center for Elder Law and Justice. And I hope we will have them with us just momentarily.
Hello?
Hello, Mr. O'Brien. We can see you and we can hear you, and we'd love to hear your story of your association with the Center for Elder Law and Justice, whenever you're ready.
Okay. Good afternoon, everyone.
Good afternoon.
Okay. Thank you for the opportunity to share my story. My name is Shane O'Brien. I'm 48 years old, diagnosed with paraplegia, paralyzed from mid-torso down with limited use of my upper extremities as a result of a severe motor vehicle accident. I'm here today to talk about the vital impact that the Center for Elder Law and Justice has had on my life over the last few years. Throughout the pandemic, I've been helped by attorneys and paralegals at CELJ with 3 separate issues, each of which were resolved in a way that improved my quality of life and secured my safety in my own home. I'd like to tell you about the help I received, focusing primarily on the most recent issue. Last year, I had a fire in my mobile home. At that time, I was home alone. I do receive 140 hours weekly of home care aid services covered through my Medicare Managed Long-Term Care Plan. But this particular day, the aide who was scheduled to provide those services did not show up. Sometimes aides don't show up, which means there's more time for me to be alone in my home without assistance. Given my limitations, I could not open the door to get outside by myself, and I could not put the fire out. Luckily, I was able to call a friend who was available and nearby. She came within minutes and put the fire out. I was very, very lucky that I was not harmed and did not lose my home. This experience of being trapped in my home while it was on fire, alone and unable to leave, was traumatic. In an effort to make it easier to leave my home, or to leave my home independently, I requested that my Medicare plan pay for an automatic door opener and have it installed. The Medicare plan denied my request, stating that in the event of a fire, if I am alone, I can shelter in place, since I did so before. I have a ramp outside my front door, but how can I use it if I can't open the door and no one is here to help me? After my experience with the fire on a day where my Medicare home care aide did not show up for her shift, I don't think I could safely stay in my home long term without having this device installed, and it is not something I could afford to do by myself. I also could not afford to pay for legal help. That is when I turned to CELJ for the third time in 2 years. I reached out to CELJ for help appealing the denial as my Medicaid plan was clearly not going to provide the door opener to me without legal help. CELJ helped me. I requested a fair hearing and began preparing for the hearing before the administrative law judge. CELJ attorneys and paralegals helped me feel prepared to speak to the judge at my hearing and encouraged me to be honest about my traumatic experience with the fire and while I was home alone. During the hearing, the CELJ attorney helped me present my case to provide medical necessity, and ultimately the judge ordered the health care plan cover the cost of the door opener and its installation. I cannot tell you how relieved I am that I was able to have this door opener covered and installed. I don't feel like it's something that just makes me more comfortable or improves my quality of life, but is absolutely necessary for my safety and my ability to remain safely in my own home. I think that the Medicaid plan would tell disabled individuals to shelter in place during a fire is truly terrifying. And it made me feel like they did not care about me or my safety. The ability to live where I choose, independently and with dignity, is something that many people take for granted. CELJ showed me they cared when my health care plan didn't, and they helped me feel safe in my home once again. I do not think that I would have been successful in getting these services covered by my Medicaid plan without the help of CELJ's legal expertise and diligent advocacy on my behalf. In the past, they also helped me with covering the widening of my doorways and having an accessible shower installed. I am very thankful for the services they provide and think they should be provided the resources they need to continue to do the work they do. I'm happy to have the opportunity to share my experience with them, the impact their services had on my life, and why their services are so valuable to me. That's what happened to me in a nutshell, and I don't know what I can say more than the way it happened, but it's immeasurable to me, the assistance they gave to me. Not once, but 3 different times. So I thank you.
Thank you so much, Mr. O'Brien. Just a question for you. How do you think you'd still be in your home today without the intervention of CELJ? And how close do you think you came to living in a far more restrictive residential situation had it not been for the help you received from CELJ?
Had I not received the help from them, I wouldn't have felt safe being in my own home. I would have probably been in some sort of assisted living. I used to be a nurse for 5 years. I was a CNA for a few years. I finished top of my class, and without having this door opener, my doors wide and the shower installed, I would definitely be in a skilled nursing or at least assisted nursing. I'm paralyzed from 2 inches above the nipples down. It's actually called tetraplegia. My hands don't work very well either. So it was immeasurable. They're really, I'd like to meet them in person eventually one day and definitely give them a handshake and say thank you.
Well, I for one am very happy to see you in your home. So thank
I
you.
appreciate that.
Any
I
questions?
appreciate that, and this is all because of CELJ.
Okay. Ms. Nicholson, why don't you tell us a little bit about your work with Mr. O'Brien?
Sure. Good afternoon, Your Honors, and thank you for the opportunity to speak today. It means a lot to me personally, having done this work for a long time, and I'm really happy to actually meet you, Mr. O'Brien, via Zoom. Mr. O'Brien was represented by my staff at the Center for Elder Law and Justice. I'm the CEO there. And as he's detailed, we've been representing him for multiple years. In addition to my role at the Center for Elder Law and Justice, I'm also the volunteer treasurer of the New York Legal Services Coalition, which is an association that's made up of about 50 civil legal aid providers across the state, and we work together to ensure access to civil legal justice for those in need like Mr. O'Brien. It's the mission of the Center for Elder Law and Justice, which we affectionately refer to as CELJ in our office, to improve the quality of life for elderly, disabled, and low-income persons in Western New York. And we do that by providing free legal services, primarily to older adults and those with disabilities, but also to the general low-income population as funding allows. And as Mr. O'Brien so eloquently put it, our goal is to do just what we were able to do for him, is to help our clients live independently and with dignity. As you heard from the dramatic testimony, our services were critically important in this multi-year quest to get the required services so that he could, not only live in his home, but also live safely in his home. And Mr. O'Brien had been our client for a couple of years before the fire, which is really the only reason he knew to call us when that last thing happened to him. So back in 2020, he first called us when his Medicaid managed care plan denied the request to widen his doors. He needed that done so that he could do his physical therapy at home, which he is entitled to do pursuant to Medicaid. In addition, the plan then later denied his request to build an accessible shower. When we stepped in each time to help, the plan did rescind their denials in those two cases without a fair hearing. But then they still attempted to force Mr. O'Brien to pay to remove his inaccessible bathtub. Through our representation, Mr. O'Brien was able to prove that these requests, as he said, were not just for vanity or comfort, but they were medically reasonable and necessary to keep him living home safely. And without coverage of these necessary home modifications, which the New York State Medicaid program clearly covers, Mr. O'Brien was at risk, as he said, of being placed in a skilled nursing facility or assisted living in order to meet his care needs. And that is a clear violation of the Americans with Disabilities Act and the Supreme Court's decision in Olmstead. Through the enactment of the Americans with Disabilities Act, Congress found that individuals with disabilities continuously encounter various forms of discrimination, including outright intentional exclusion, the discriminatory effects of architectural, transportation, and communication barriers, overprotective rules and policies, and failure to make modifications to existing facilities and practices. In 1998, the Supreme Court found that the ADA provides people with disabilities the right to reside in the least restrictive setting, where their health care needs can be met, and noted that states could provide these services through a Medicaid waiver program, as they do in New York. Despite the intent of Congress from more than 2 decades ago to eliminate discrimination against people with disabilities. You can see the burden very clearly falls on individuals like Mr. O'Brien. Sadly, he's experienced these discriminatory effects due to the failures of his plan, and it's that exact type of discrimination that Congress intended to eradicate through the ADA. Without our advocacy in all three cases, Mr. O'Brien would have been at risk of some form of institutionalization, even though, as you can see, he can clearly be cared for and should be cared for in his home. His case dangerously illustrates the barriers that individuals with disabilities face every single day, and how access to justice is so critically important for them to ensure these essentials of life. According to the 2022 Legal Services Corporation Justice Gap Report, the pandemic has had devastating and disproportionate impacts on low-income Americans, with 47% of them experiencing at least one civil legal problem in the last year. This is a pandemic impact is also reflected in our statistics at CELJ. Healthcare access, as Mr. O'Brien discussed, is really just one of the areas where we practice in. Overall, between 2019 and 2020, our agency-wide cases increased by 26%, as people attempted to navigate unemployment, healthcare, public benefits, all during the initial months of lockdown. Even after lockdown, our numbers continued to be high. In 2021, we opened a total of 4,607 new cases, and we served more than 10,000 people. One of those people was Mr. O'Brien, and I thank him again for his testimony today. I'd like to close by noting that although the justice gap is significant for all low-income people, it is even more profound when looking at underserved populations such as the elderly or disabled. According to Justice and Aging, nationally, 45% of individuals over the age of 65 can't even meet their basic needs. According to the Legal Services Corporation, there are 7.6 million seniors in poverty in the United States and more than 11 million people with disabilities. And this need just keeps growing every day. According to the federal government, 10,000 people are turning age 65 in the US each and every day. So these statistics demonstrate the ever-increasing need to bridge the justice gap, particularly for those most vulnerable among us. And I really do appreciate your dedication to these issues and the opportunity to share our experiences. Thank you.
Thank you, Ms. Nicholson. The quality of the work you do with the elderly and disabled is evident from the result you received here. And I just want to thank you for all that you do for this, you're right, critically underserved community.
Quick question?
Sure.
CEO Nicholson, you are always out and endeavoring to raise funds, aren't you, to help your mission? You're here today, I think, where you're supposed to be somewhere else, aren't you? Isn't there a fundraiser going on at Wanaka to help you with your mission?
Yes, today is our golf tournament, Judge.
Yeah, well, I know that because I get emails on a regular basis, and I would like to be there also, but we both find our time busy here, right? Yeah.
A little busy today.
You do a wonderful job, and we
Thank
really
you.
appreciate your efforts. Thank you.
Thank you, appreciate it.
Thank you very much, Mr. Cool.
Well, I don't want to delay anyone from an important fundraising goal. So,
Or a Bills game.
or a Bills game.
Yeah, or a Bills game, right?
Go Bills. Go Bills. I got my jersey on, guys.
So I will let you go, and we'll move on to our next presenters. But thank you both very much.
Thank you so much. Thank you, Mr.
Thank you
O'Brien.
very much. Bye-bye.
Our next presenters will be Vincent and Linda Mesenzio,
Sure was.
and their attorney, Samantha Agwam, from the Volunteer Lawyers Project of Central New York. Vincent and Linda are both clients of the Volunteer Lawyers Project of Central New York, and Ms. Agwam has agreed to join them as well today to talk about their experiences regarding debt collection issues that they had. Can you see and hear us, Vincent and Linda?
Yes.
Yes, sir.
Okay, well, we're ready to hear your story whenever you are.
Okay. My name is Vincent Mesenzio, and I'm 72 years old. My wife Linda and I live in Central Square, New York, which is a small rural community in Oswego County. We've lived here for over 40 years and own our own home, which is the only asset that we have besides 2 beautiful children and 7 grandchildren. For over 20 years, I maintained a small taxi business. It supported my family. My clients consisted of senior citizens who used my services for doctor appointments, grocery shopping, and also consisted of non-essential employees going to work. In March of 2020, COVID shut my business down. It came to a screeching halt. I was not able to service any of my clients, and my VA doctors advised me that continuing to work would compromise my health issues. My only source of income was my Social Security, Linda's Social Security, and a small 10% disability from the VA. I truly was at a very low point. When my wife Linda and I turned to the VA for help, the VA social worker recommended that we contact the Volunteer Lawyers Project of Central New York. That's when we first met Adam Martin. That one phone call that we made, with many to follow, set things in motion. I told Adam that I had accumulated $16,000 in credit card debt, which consisted of 5 credit cards, mainly from business expenses. Adam first recommended answering any written correspondence by stating that our only source of income was Social Security and my small VA disability. He advised me that this was safe from garnishment. 3 credit card companies threatened collection proceedings. Adam in return followed with a cease and desist letter. After this was put into motion, 2 of the companies stopped collection proceedings. However, the third one served me with a summons and complaint. It became a roller coaster ride over several months, but Adam and his supervisor, Sally Curran, walked us through the process. From our answer to the summons and complaint, including counterclaims to discovery, and then defending against the motion for a summary judgment. Finally, on July 8th, 2022, the plaintiff agreed to a discontinuance if we agreed to drop our counterclaim. Volunteer Lawyers Project helped us out of this unfortunate situation, and we learned some valuable lessons regarding debt collection process. We will forever be grateful to the Volunteers Lawyers Project of Central New York.
Thank you very much, Mr. Nicenzio. Any questions? We appreciate you coming to tell us your story, and I'm glad that things worked out and that you were able to connect with VLP. Maybe Ms. Agwam would like to tell us a little more about how that happened.
Yes, I'd be happy to, Your Honor. Thank you for having me. Appreciate it. And thank you, Vince and Linda. We appreciate your kind words. Thank you for having me today. My name is Samantha Agwam, Sam Agwam. I am currently the interim executive director of Volunteer Lawyers Project, along with my colleague Mary John, while our executive director is temporarily out of office. I will likely refer to Volunteer Lawyers Project as VLP or VLP-OCNY just to save a little breath as I talk about what our services are. VLP of Central New York has a central office in Syracuse City, New York, in County of Onondaga. However, we serve several other counties in CNY region and beyond in New York State. VLPSCNY began in the 1990s as a branch of the Onondaga County Bar Association with just one staff member. Today, VLP of Central New York has since become its own 501c3 not-for-profit organization that is the largest provider of pro bono legal services in Central New York. VLP of CNY staff of 20 leverages energies of a pro bono panel made of 500 attorneys, law students, and other community volunteers to provide civil legal services to over 3,700 clients on an average year. The mission of Volunteer Lawyers Project is to provide access to justice through engaging the legal community and volunteer services for those in need. We work closely with local legal services providers to identify civil legal needs that are not being met by other organizations, and then we harness the energy of volunteers to meet those needs. VLP serves civil legal needs covering the essentials of life, including family matters, access to health care, and education. Low-income individuals access our programs through clinics located in courthouses and community-based organizations, through telephone-based services, and through direct referrals and collaborations with other legal services providers in Central New York. VLP operates these court-based clinics to provide advice and assistance for unrepresented litigants with preparing petitions for family court, surrogates court, and an average year VLP will defend over 1,000 tenants in eviction proceedings in Syracuse City and East Syracuse Justice Court, avoiding or delayed evictions in 75% of those cases. In addition to those clinics, VLP provides ongoing pro bono assistance with a wide variety of cases, including uncontested divorce, elder law, trust and estates, assistance with nonprofits that work with low-income individuals with issues affecting the essentials of life again. Our New Start Reentry program provides ongoing assistance to job seekers and removing barriers to employment, and our Community Economic Development program assists low-income entrepreneurs. Our Q-Law program assists transgender clients with name changes and discrimination cases. And finally, our Claro program, that's the Consumer Legal Advice Resource Office program, has attorneys that provide free legal advice and help with drafting court forms to fight debt claims. Help is provided for court cases on or judgments related to credit card debt, medical debt, student loans, car loans, utility collections, lines of credit, and charge accounts. This program is offered with a collaboration with our local Syracuse Financial Empowerment Center, which has been a great collaboration as well. VLP in general and our supporters strive to engage volunteer attorneys and professionals, conserve time to train those volunteers, support our staff, and continue our programming. This is for the seemingly endless need for civil legal services, which since the COVID-19 pandemic has become ever present and is greater than ever before. In particular, there's a pointed insufficiency of pro bono legal services available to help people outside the metropolitan area. Unfortunately, the vast majority, unsurprisingly, the vast majority of pro bono legal aid services are concentrated in New York City. In terms of population density, New York City does have the highest concentrations of persons requiring access to legal services. However, venture beyond Westchester County, where the percentage of poverty per capita is 8.3%, and you are quickly in the double digits. In Franklin County, the county farthest north geographically from New York City, the poverty rate is 16.7, more than double. The counties in Central New York account for pretty much the statewide average at 13.6% poverty rate, which is what the rate is in Onondaga County, Syracuse here. For clients like Vince and Linda who live in Oswego County, the poverty rate is 16.1%, and there are no pro bono legal service organizations based in that area. Plainly, in rural areas, we have a higher level of poverty per capita with a lower number of attorneys per capita, and even fewer attorneys that engage or are able to engage in pro bono legal services. While the statistics are impactful, they are certainly not surprising. In the fall of 2019, the State Bar News ran a cover feature outlining the problems that rural communities experience due to low lawyer shortages in small-town New York. And in April of 2020, NYSBA, New York State's Bar Association Task Force on Rural Justice, produced a report which identified sources of this problem as the graying rural bar, low attorney to resident ratios, the sprawling gamut of legal issues, and above all, the overwhelming need for funding in order to attract practitioners to meet all of these challenges. In response, Volunteer Lawyers Project and 3 other legal aid organizations based in Syracuse routinely field all matters of legal questions from the upstate area, central New York area, western New York counties, including evictions, landlord-tenant disputes, immigration, LGBT rights, elder law, surrogates court, custody, divorce, small business, reentry, and most of all, and sometimes almost always debt, which it seems like everybody seems to have, unfortunately. Especially now in the year of COVID, we have seen clients with upwards of $50,000 to $660,000 worth of outstanding debt, stemming from medical bills, compounded by rental and child support arrears, and debts from store cards like Vince and Linda's. The debt industry has adopted a business model in which 75% of all credit card debts go sold to debt buyers. The going rate for debt purchase amount fluctuates, but the average is 4 cents per dollar, which is a very generous profit margin. On the consumer side, only 4% of people are represented when sued for debt. Why is this? Maybe because people simply don't know there are resources available to them. There's also personal embarrassment where you are not able to keep up with your payments, geographical isolation, and a general notion that there's really nothing that can be done about the situation. Consequently, there are over 100,000 default judgments against consumers per year in New York State. This compounds and perpetuates the debt problem. The situation is alarming because in less than 10% of the cases, the debt buyers do not have the required paperwork to pursue the debt legally. This paperwork includes account statements and application terms and conditions of original credit offer, payment history, and required affidavits. As we know, in 2007-2008, the buying and selling of debt without these documents was a major factor in the housing crisis that led to the Great Recession. For cases like Vince and Linda's, persistence was really key. Knowing that only 10% of the debt of the time of a debt collector has the proper paperwork to pursue the debt, we were able to make the process more difficult for debt collectors. Even just answering the summons and complaint and raising counterclaims often is enough to make the debt collector reevaluate whether or not it is a financial advantageous to pursue the case. The more pieces of paper you have, the more their pennies per dollar profit model is eroded. With Vince and Linda's court case, we started with the answer, then moved to discovery interrogatories, which went unanswered despite repeated requests. We were on the verge of submitting a motion to dismiss when the creditor sent them a letter offering them to stipulate a discontinuance if we would drop our counterclaims. COVID-19 has deepened the impact of these conditions and dramatically slowed the process of recovery from debt. These proportions threaten to leave a large segments of our rural communities without critical legal resources. It's little wonder that the New York Bar Association report on the rural justice recommended, above all else, funding related interventions. For VLP of Central New York, the delivery of our services relies completely on the receipt of steady, reliable funding. Without these grants, these critical legal services would go unprovided, and these rural populations would go totally adrift from the court system and access to justice. Thank you for your time.
Thank you, Ms. Agwam. I suspect you might be one of the hardest working attorneys in Central New York.
Oh, no. No, I have a wonderful team, Your Honor, including who Vince and Linda mentioned, Adam Martin. I do want to make a shout out to him. He was crucial in the success of their case. Amazing.
We are very grateful for his work with the Bacenzios. I noticed in going through your materials that you leverage the services you provide by seeking the assistance of non-legal professionals. You have a number of volunteers and other people who work with your clients. And I'm just wondering whether you would be able to service even those 3,700 clients a year that you service without the assistance of non-legal professionals, and relatedly, whether you see that as in any way positively or negatively impacting the quality of the service you provide.
Absolutely. That's a good question. So when I say the non-attorneys, I do mean a large percentage of law students that support almost all of our programs. We really crucially need them for anything from intake to research to whatever it may be to support our programs. As you mentioned, also other non-attorneys, which would include paralegals, even just administrative experience folks. I absolutely do not think we'd be able to serve that as many clients as we do without that support of the non-legal community. I think it is a good thing, absolutely, because what we try and strive for, and I know all the other legal services do as well, is to think out of the box, right? It's not necessarily with our services that we have the traditional client-attorney relationship. We have services that are limited to a one-day representation, let's say in landlord-tenant court, to limited advice and counsel on help filling out petitions to file with family court or surrogates court, to a complete full representation on a matter like what Vincent Lynn does. So we try and think outside the box in terms of how we can serve the most clients with both, if we don't have enough attorneys to take on the traditional attorney roles, how can we fit non-attorneys into that?
Thank you. Thank you so much for your time. We appreciate everyone's testimony, and we wish you all very good luck. Thank you.
All right, thank you.
Thank you so much.
Our next presenters will be first name Kerry, who is a client of the Legal Project, and we will also be hearing from Michelle Rich Pollock, who is the executive director of the Legal Project. And we will wait for them to come on screen. Thank you. I can see that Carrie is now unmuted. And can you just voice check for us, Carrie?
Sure. Can you hear me?
Yes, we can.
All right. Excellent.
And we're ready to hear your testimony.
Excellent. Good afternoon. First, I would just like to thank the esteemed panel before me and for being receptive to hearing the need for these civil legal services today, and for the extreme honor to be the real face in which these services have benefited. I do have to say this is quite the platform for me to share just a small fraction of my story publicly for the first time. But I really appreciate you allowing me the opportunity to show a face of someone who has personally benefited.
Thank you for being here.
On the day of August 29th, 2011, I lost my home in Hurricane Irene. I was 8.5 months pregnant after losing my daughter in a previous pregnancy in utero, and I left with my animals and the clothes on my back. People helped. I was beyond moved and grateful for all the help we received to rebuild our home. There was one thing that could not be saved or replaced: my husband. My husband chose the bottle. He chose inebriation over determination, which ultimately ended in addiction and domestic abuse. I see now, after looking back, my now ex-husband was this person all along, but used less obvious vices and manipulations. I did not see it because I simply didn't think that some people would seek to manipulate and control in the most subtle ways and completely strip you of your own life. I had made the decision on April 3rd, 2019, to leave my home, my marriage, and my life as I had known it for 2 decades. I left with $0, no home, and no job. I had my son as my priority, was his well-being, where my now ex-husband's priority was control. On November 19th, 2019, I was picking my son up from a visit with my husband, and my husband struck me. My son witnessed this. I remember immediately thinking, stay strong, call the cops, don't scare Daniel. It was in this moment that the advice of my parents that they've given me my whole life flooded my mind. No one can put their hands on you. If you need help, call us. We'll always be there for you. Stay calm in overwhelming situations and you will receive a better outcome. Breathe. Later, I was shocked when my calmness in that moment was presented as evidence of deception or strategy on my part. In a whirlwind of events that happened after this, from the cops telling me to meet them at the station, to my ex-father-in-law walking into the station while my son and I were waiting there to sign paperwork saying, I hope he left a mark. I was also introduced to the YWCA and the Legal Project. Attorney Storm advised me that divorcing a person like my ex would not be quick. She could see farther into my future than I could, as I was just trying to survive. My ex manipulated our system to find loopholes and excuses to keep me homeless, broke, and in litigation as long as possible to ensure I couldn't afford to continue and to continue his own abuse cycle. My ex was at best minimally involved in my son's life prior to and even after our physical separation. It wasn't until the night that I had him arrested that he began to use my son as a pawn to make my life miserable. It was right after I was physically assaulted that he filed for 50-50 custody of my son to retaliate while not bothering to show up for visitation that he already had. I was homeless throughout the entire custody case and unable to secure housing until the divorce ended. I was lucky enough to keep my son in his school district by virtue of his rights as a homeless student, and my ex was fully aware that the delays caused by him kept us from securing housing. The initial custody case was scheduled for a 5-month lifespan with a trial in May 2020, but was delayed by over 18 months, in part by COVID, but also by my ex's numerous delay tactics of not filing documents, claiming to be out of town, and strategic attorney changes multiple times at critical moments in our case. My ex is self-employed. He never once provided tax returns, not even to this day. He successfully claimed to only earn $15,000 annually. I was divorcing a con man, and a good one at that. He's a certified private investigator who knew how to work our systems and instill fear to get his way. Throughout litigation, my ex repeatedly asked me, through his representation, to recant about the domestic violence. There were 2 reasons he wanted this. 1, to clear his name, and 2, to receive his guns back. With every claim or counter, there was always an ask of me to sign a letter saying that he didn't assault me and telling the judge to return his weapons to him. The clear implication was that his claim for 50-50 custody was intended to coerce me into lying to cover up his abuse. It was a bargaining chip to get me to say the assault didn't happen and that he can't have his guns back. Attorney Storm assured me time and time again that because he rarely showed up for scheduled visits, that he would not have a chance at 50-50 custody, and encouraged me not to write or sign such a letter. The physical assault was actually caught on video, but his attorney repeatedly insisted the assault didn't count because I was also angry at the time of the assault. My ex had just destroyed thousands of dollars of my personal property, and that I was too calm afterwards. They withheld this video and this footage for many years until it was finally produced and the assault was clear as day. I was beyond overwhelmed. I would blindly take every piece of information that Attorney Storm gave me and held it close to me, not knowing how it would help, but trusting her that it would all make sense in the end. Every step of this was excruciatingly painful and exhausting, and I do not believe I would have ever made it through without her or the legal project. It takes extreme faith to put your trust into someone you just met after your trust was destroyed by your abuser. I had nothing left to lose, literally, and trusting her was all I could do to help ease the worry of keeping my son and myself as safe as possible. While family and friends tried to understand and help, they didn't understand and couldn't comprehend why certain things were a certain way. I would often ask for their help and input, which would leave me feeling frustrated and isolated. The legal project did not have the resources to help me with my divorce, but they did help me in custody, and honestly, that was all that mattered and still matters the most to me. I have the contrast of private representation and the representation of the legal project because of these circumstances, and I assure you, the level of care, concern, attention, and compassion exceeds that of private representation. I never once felt that I was brushed aside because of caseloads being too great. I had a lot of questions, no knowledge of the legal process behind this, and no money to pay for any of it. I'd like to fast forward to today. There isn't a day that goes by, or even an hour, that I don't think of Attorney Jennifer Storm or the legal project. Ask anyone in my life and they will tell you how often I express my gratitude towards her and the legal project. I am finally happily divorced. I have an amazing job, and I have just purchased a home for my son and myself. I have succeeded in my own eyes, but only because of the help of the Legal Project and attorney Jennifer Storm. I assure you that Attorney Storm will give me all the credit, but it was her that I would think of on sleepless nights when my heart raced over a simple text from my ex that triggered me. It was when I did not know how to handle when my son was not returned to me when he was supposed to, that Attorney Storm was there. The Legal Project provided the most valuable and irreplaceable assistance that I acquired in the last 3 years of my life. If only everyone in this situation like mine had the opportunity to be helped by them. It is in these words that I am now able to help others and let them know the Legal Project is there for them.
Thank you, Carrie. That was a ringing endorsement of the Legal Project. I note in your comments, you said sometime around November 19th, 2019, you were introduced to the YWCA and to the Legal Project.
Correct.
I'm just curious, those are two strange things to happen at the same time. How did you get introduced to the Legal Project?
It was a whirlwind of a night, but the YWCA does this amazing thing on any arrest for domestic violence, and they put a little stamp on the paperwork. That stamp ultimately led me to the YWCA, and they collaborate with the Legal Project, and they were referred to me by the YWCA.
That's wonderful.
Yes, it was wonderful.
How soon after you went to the YWCA did you have your first meeting at the Legal Project?
Within a week.
That's great. Thank you. Any questions for Carrie? Thank you, Carrie. We're going to hear from Ms. Rich now, I think. Is that correct? Whenever you're ready.
Okay, thank you. Thank you to this esteemed panel for the opportunity to provide remarks this afternoon. I know you've had a long afternoon. And thank you, Carrie, for sharing your story with us. I know it wasn't easy, and you did great. And congratulations on buying your home. I hope that you and your son will always be safe and happy. I am Michelle Pollock-Rich, the Executive Director at the Legal Project. And for 27 years, the Legal Project has provided free legal advice and representation in the Capital Region of New York State. We were founded in 1995 by members of the Capital District Women's Bar Association, who had been providing pro bono services to victims of domestic violence who were trying to navigate the family court system. And these pioneering attorneys witnessed firsthand the harm that can occur when a victim of domestic violence goes unrepresented. And out of their experiences, they founded the Legal Project. And over the years, we've expanded our practice areas in response to the needs of the community. So today we provide consultation and representation in the areas of domestic violence, crime victim assistance, affirmative immigration, human trafficking, civil legal assistance, family law, foreclosure defense, and other matters as well. And we also provide training to the legal community on domestic violence best practices in law and trauma-informed approaches in law. Legal assistance for victims of domestic violence remains the largest part of our work, though. And as I think Carrie's story emphasizes, legal assistance is a critical step to helping domestic violence clients move forward with their lives in safety and with an understanding of their legal rights and their legal entitlements. Domestic violence is about power and control, specifically coercive control. And coercive control is a pattern of behaviors in which one partner exerts power over another person by controlling them through fear. A victim's fear and an abuser's control do not stop at the threshold of the courtroom. I wish it did. And while it's often invisible to the outside observer, these dynamics continue to influence court outcomes and justice itself. An attorney helps to correct the imbalance of power between the parties so that the court can make impartial, just rulings. And without legal assistance, domestic violence victims often give up their rights in an attempt to avoid future conflict. But abusers don't want to be appeased. They want to be in control. And many use the court system itself, filing vexatious lawsuits, to keep the victim returning to court, weaponizing our court system in their favor. And in some cases, they do it to see the victim when there's an order of protection because there's no other way. But in most cases, it is simply to exert power and control and keep the victim, who would like nothing more than to put an end to the legal proceedings and move on with their life, returning to court and wearing them down. To be effective, attorneys working with clients who are victims of domestic violence require expertise in the dynamics of domestic violence and an in-depth understanding of trauma-informed practice. And all of this can be learned, but it takes time and dedication and experience and heart. And when they are learned, the result is an attorney like Jennifer Storm, Carrie's advocate and also our DV supervising attorney. Jennifer would be an asset anywhere, and I hope we can keep her. As you know, and you've heard a little bit today, the whole country is in the grip of a hiring crisis. Here in Albany, we compete not just with private law firms, but also with New York State. And although at the Legal Project we make every effort to be the best employer we can be, we find ourselves unable with current levels of funding to compete with the salary and benefits and stability offered to state employees. Nonprofit employees have the strange distinction of becoming accustomed to the instability of grant funding, meaning when a grant ends, there is no guarantee of continued funding for a program. Programs end, jobs are lost, regardless of how good programs are or how much they're needed by the community. So a vague sense of fear permeates employees in grant-funded programs. And during COVID, this unease sent many in the nonprofit sector, not just at the Legal Project, but across the state, into the comparative stability of state employment or sometimes private sector employment. And as you've heard from many of my colleagues testifying today, the community need is never ending. And over years of sustained insufficient funding, nonprofit salaries and expectations are artificially low in our attempt to do as much as we possibly can with the resources that we have. And as a result, nonprofit employees have borne a lot of the burden. They are the hardest working people you will ever meet, and they forego cost of living increases, they forego fair salary just to be able to help their community. But at the end of the day, they can't eat the mission, and they should be able to get to court without worrying if their car is going to break down, and do things like be able to purchase a home and move on with their lives, knowing that they have some job security and that, you know, they may be looking for a job in a year and a half when their 3-year grant comes to an end. Our employees are highly skilled, highly trained professionals, and they're paying a price. And we need people like Jennifer for her level of experience, her expertise, and her heart and her passion. So I urge you to consider what I hope is a modest request today. We need you, we in the nonprofit sector, we need you to be our advocates, not just in the JCLS process, but across the many state agencies that help to fund legal services. Most legal service organizations have a tapestry of funding, and for the Legal Project, much of that is here in New York State. Urge our colleagues to execute our contracts on time and to pay us in a timely manner. Work to increase civil legal services funding overall so that we can meet community demand and provide our employees at least the same salary and benefits as our colleagues in the state without sacrificing the number of clients that we serve in order to do so. Please consider the process by which funding is distributed. So instead of spending our time competing with other legal service providers for dollars, we can collaborate with them and work with them together to help solve the problems in our community and provide for more clients. Help our employees feel safe so that they can concentrate on their clients, not on job searches. And finally, one more. Please consider continuing virtual court as much as it is appropriate. It helps victims of domestic violence feel safe, especially in these vexatious demands to return to court, which can be, I know, very difficult for the courts to tease out, you know, what is a reasonable demand and what is just to torture a victim. Video court does help them feel safe. They don't have to worry about running into abusers in parking lots or staring at them across hallways or even bumping into opposing counsel. And it also helps our attorneys to be efficient with their time. Instead of traveling back and forth to courthouses, they can be very efficient and spend more time with the client in front of them. So I hope that these are modest requests. Our employees love the work that we do. Even flat, what we call flat funding, no increase, no decrease, is really a funding cut when you think about inflation. And some of our funding sources have continued flat funding over the last almost 5 to 10 years, depending on the source. So we're not just trying to do more with less. We're trying to do the same with levels of funding that are effectively a decrease, even though on paper they are the same. Again, Carrie, thank you for your very powerful words, and thank you to this panel for all of your time today and for everything that you do and have been doing to work to ensure access to justice for all New Yorkers and everyone in our community. It's been my honor to address you today.
Thank you, Ms. Pollock-Rich. That was a very comprehensive list of requests. Just modest enough, and I'm not going to ask any more questions of you since I don't know if there would be more requests attached.
I might think of one.
But I do want to commend you for your work, and I especially want to express my appreciation to Ms. Storm for her obviously excellent representation, and Carrie, really, thank you so much for coming today. I know it was anxiety-provoking, so I appreciate it. And I think we have a question from Ms. Wallach.
Thank you, Judge. First, thank you so much, Carrie, for coming here and sharing your story. I know it was probably not easy, certainly not easy. And congratulations on your successes. And I want to speak from one Deputy Executive Director of a legal services organization to another, and understanding and thanking you for speaking so clearly about the concerns in funding and certainly in employment. And while this question may have been answered indirectly, I think it deserves a direct answer, because one thing that Carrie mentioned in her comments that really struck me in this context was that the legal project did not have the resources to help with her divorce. And in the context of what she was going through, I can imagine that that was difficult. And so I would like, if possible, for you to speak to, what the reasons were for that and how we could have helped in that regard, potentially, as a legal community.
I would say that sometimes timing has a bit to do with it. We did experience quite a bit of turnover in the early days of the pandemic, as I had mentioned, as a number of employees moved to the government sector and moved out of nonprofit to the private sector, and they're very difficult to replace. It takes a lot of training and a lot of time to get somebody of Jennifer's caliber. We are very careful in our hiring, but the reality is that we have, until recently, 5 open positions. We've just filled 2, and we still have open positions in our domestic violence unit. And we're not able to attract top talent because I think that the nonprofit sector, over the years, again, in our attempts to use our resources to serve as many people as possible, we have in some ways contributed to those low salaries. And it takes time and effort and years to bring those salaries up, especially through grant funding. But we have been working hard to do that. So I believe it was a combination of, one, we are short-staffed, and as a contributing factor to being short-staffed, it's hard for us to be competitive in this market. I hope that made sense.
It did make sense. Is there anything that you can think that a state bar or a bar association can do to assist in that gap?
We have a very active pro bono panel. Depending on the time, we've had up to, 180 to 200 pro bono attorneys helping us, especially in our different types of legal clinics, including our pro se divorce clinic. But we don't like to send our domestic violence clients to a pro se divorce clinic. It's really not appropriate. So really, I think that the most effective thing that we can do is to acknowledge that our domestic violence attorneys are trained to work with this very specific population. And even pro bono members of the bar, unless they've gone through our domestic violence training, they don't always understand the dynamics that are happening as much as they would like to. So ideally, we would be able to, adequately compensate our employees, attract employees. It's not just about the compensation. It's about this feeling of instability, right? When the grant ends or if the funding is cut, I'm going to lose my job. And I've had many people say that to me over the years, not just in the legal project, in the nonprofit sector in general. And the problem is that they are right to be afraid, because most nonprofits run on a very small margin. And if a program's funding ends, the program ends and the employees are laid off. So creating stability, acknowledging that nonprofit professionals are highly skilled. It's not just this little thing we're doing. They're highly skilled people toiling to make our communities better. So that respect and that stability and that compensation, I think, would go a long way towards helping us to help more people like Carrie.
Thank you so much. We will
Thank you for having me.
do our best.
Thank you.
Appreciate it. Thank you. Our final client, provider, presenter group today are Kamari Banks, who is a client of the Legal Aid Society's Education Law Project, and Ms. Adrienne Holder, who is the chief attorney for civil practice at the Legal Aid Society. And we will be hearing from them in just a moment. We're going to start by hearing from Kamari, who will tell us her story, and then we might have some questions for you too, Ms. Holder. So Kamari, whenever you're ready.
Okay. Hi, good afternoon. I'm Kamari Banks. I'm 18 years old. I'm a senior at City Eyes High School in Manhattan. I also work at Urban Adventure Park in Trampoline. And I live in an apartment in Queens with my mother and my 3 younger siblings. And I also dance as a member of a dance group. I am here today to share with you how the work of the Legal Aid Society Civil Practice Education Law Project has impacted my life. Growing up, my mom, Tanisha Aiken, provided a solid, loving home for me and my siblings. My mom encouraged me to take school seriously and take ownership of my life. Two things that have stuck with me and served me well as I've gotten older. At school, though, I've often had a different experience. Instead of the warmth and support I felt at home, I often felt attacked just for being who I am. I started getting bullied around the time I was 9 years old. I was told I wasn't masculine enough, which honestly confused me. I was just being myself, and because I had always been accepted at home, I didn't understand why not showing enough masculinity was looked at as a problem. Something I should be ridiculed for. Although I worked through it for most of my time at school, these attacks were exhausting and traumatic. It was sometimes hard to stay motivated at school or to keep my focus on my schoolwork and the positive things in my life. Throughout most of high school, the bullying and the threats got worse, especially on social media. In the beginning of 2022, I was a student at Fluid Finance High School, where I was involved in a physical altercation. My identity was the focus. The altercation was the combination of several events where another student was bullying me. Before the incident, I tried to talk to the school personally about the situation this time, but I felt that no one heard my concern. Nothing was done by the school staff to resolve the situation. Ultimately, on March 7, 2022, I was suspended, and I got a letter in the mail saying that I need to show up for a suspension. To my surprise, in addition to the fight, the school made several false allegations about me in the suspension letter. My mom helped me connect with Joel. Joel, go ahead. Okay. Just tell them who they are. You know who they are. But my mom helped me connect with Joel and Marie, two attorneys from the Legal Aid Society Education Law Project. They agreed to represent me in the suspension case. They helped me get the advance package in my case before the hearing date. They went over the facts of my case with me. They explained the law in a way that helped me to understand and participate in defending myself against the claims made by the school. On the day of the suspension hearing, both Joel and Marie came with me. They helped me get some of the more serious charges reduced. This also helped to reduce the total amount of days I was suspended. I remember at the suspension hearing, the hearing officer asked if I wanted to transfer school. I said that I did, that I was not going back to full confinement because I did not feel safe there. Even though the Department of Education, the DOE, and the suspension office said they would offer me a different school, this never happened, which didn't. I never heard from the DOE after I asked for the transfer. In fact, it was my lawyers from Legal Aid who continued to look for a different school for me. They spoke with contact in at City Eyes High School, a public transfer school that offers fewer and longer classes, and then an internship for a few days per week. With their help, I was accepted at City Eyes School. I chose an internship at a pond. I really enjoyed it at City Eyes. I feel like I can be who I am and continue to explore who I am. I know that most kids like me don't have anyone advocating for them at their suspension hearing. So having legal aid there as well as my mom made me feel supported. The Education Law Project is a union in legal aid civil practice. They work on a variety of cases advocating for low-income children. ELP helps young people through and beyond whatever educational issues they face. The ELP team understands that most of the time, kids are dealing with more than one issue. I understand from working with my attorneys that suspensions are somewhat of a portal to the school to prison pipeline, especially for Black and Brown as well as LGBTQ students. My lawyers believe if they only handle the suspension and don't get to the root of the issue, then their job is not finished because they haven't helped to set kids like me up for success. They haven't helped to set kids like me up for success. I just started my senior year and I'm looking forward to graduating. I have many interests and I'm not sure what I would do in the future. I love science, so I was thinking about becoming a researcher or a scientist. I've also thought about going to the military or studying real estate or being an RN, registered nursing. Or teaching. Because I no longer have to deal with the attacks I faced after finance, I have been able to focus on my education and personal interest. Since I have been at City School, I have had several positive experiences. Academically, I earned passing grades in all of my classes. I continue to participate in my dance group. And of course, I have the job at Urban Air. In order to help my family, I have to work. I love to dance and plan to continue doing as much as I can. I danced with Secret Society Dance Company for several years. Dance has been my calling, my outlet through dealing with all the stress of being a teenager. My dance coach, Trayvon Middleton, has been an important mentor for me and has taught our team not only how to be better dancers, but also how to be better people by including political and human rights issues in many of our routines. No one discriminates against me when I'm dancing. I want to make sure to find spaces like this as I get older. In the end, now that I can look back at it, I see the people who bullied me were more unhappy and insecure with themselves than anything else. There were a lot of demons trying to take me down in my old school. There was a lot of animosity there. Now I also try to think about how what I say might affect someone else. I stop and think about how the person might feel before I say something. I am grateful for help and the support I received from Joe and Marie at the Legal Aid Society because I can focus on the positive parts of my life and explore my dreams and hopes without force or fear. The Legal Aid Society provides essential legal services and advocacy for New Yorkers. I've been told that so much of what legal aid does will not be possible without the consistent investment of judiciary civil legal services funding since 2011. Thank you for the invitation to appear before you today and share my story.
Thank you, Kamari. That was a very powerful story, and I want to commend you and tell you that I think it was very lucky for you that your mom knew to seek out legal aid to connect you with the help that you needed at this particular point in your life, because I think it was a critical moment in your life. And I know you're 18 now and you're an adult. From where I sit, 18 still seems pretty young, and you know your life could have gone in any number of directions at that suspension hearing, and it seems like it really went in the best possible way for you. So I'm thankful that you found the help that you needed, and I wish you luck in your future career as a researcher or a scientist or in the military or in real estate or nursing or psychology or teaching. But I appreciate you taking the time to share your story. Anything else for
Thank you.
Go ahead.
Thank you.
Tamari, good afternoon. I just want to thank you as well for the courage to come before us and tell us your story, and also to highlight in a real way what Ms. Holder, I anticipate, will tell us the importance of a holistic approach and holistic advocacy to treat you as an entire person, not just one who had an issue with suspension, but to treat your educational issues as well as the school and beyond those educational needs. So thank you very much for presenting that in a way that helps us to grasp sort of in real time what that holistic advocacy would entail. Thank you.
Thank you. Thank you. I appreciate it.
Thank you. Ms. Holder, would you like to make a comment?
I'm sorry, I didn't hear you clearly.
Did you want to make a comment to the panel?
Oh, yes, if I might. Yes, thank you, Judge. So good afternoon. I'm Adrienne Holder, attorney in charge of the civil practice of the Legal Aid Society. I first want to thank Acting Chief Judge Anthony Camatero, Judge Diane Renwick, Judge Hector LaSalle, Judge Elizabeth Gary, Judge Gerald Whalen, Chief Administrative Judge Larry Marks, and New York State Bar Association President Sherry Levin-Wallach for the opportunity to address you all today. The Kamari Bank's experience is a reminder to all of us that without the proper supports and services, kids, and especially those from marginalized communities, are easily funneled into school-to-prison pipeline. Conversely, Kamari's story is an illustration of how the proper supports and services can help divert kids away from that. Schools disproportionately discipline certain groups of students, especially related to intersectionality issues, This occurs not only through suspension and expulsion, but also by referring students to law enforcement or emergency services. Students subjected to these policies often achieve at reduced levels. They feel disconnected from school and may eventually leave or be pushed out of school. This treatment by the educational system steers those students towards juvenile legal systems and adult prisons, a pattern known as the school-to-prison pipeline. The school-to-prison pipeline is fueled by a variety of factors, such as the failure of school and law enforcement professionals to understand that emotional learning and/or developmental disabilities are often at the root of apparent misbehavior. Many students who have experienced trauma present as anxious, depressed, explosive, or disengaged, and traditional punitive behavior management systems such as classroom removals and suspensions do not effectively address these behaviors. Further, these systems do not provide the trauma-informed, healing-centered, and anti-racist interventions necessary to place students on a path to success. In fact, they often exacerbate the problems. The Legal Aid Society handles scores of suspension cases each year. Representation at suspension hearings is vital for kids who are suspended from school. Most kids do not have representation, which allows the Department of Education to trample over their rights. Just the fact that Legal Aid is there to advocate for these kids is an important factor in helping to stop the flow of the school-to-prison pipeline. However, advocacy at a suspension hearing, even if the child wins, is not the end of the story for us. In every suspension case we take on, we work to ensure that the child is set up for success after their suspension hearing. Sometimes this means getting special education evaluations done and holding an IEP. Sometimes this means requesting and obtaining a wide array of supports for the student when they return to school, such as a behavior intervention plan or at-risk counseling. Sometimes, as in Kamari's case, it means finding a school where the student will feel comfortable and be able to be themselves. And many of our clients, so many of our clients are high school students, so we work to ensure that they're on the path to graduation instead of the path to prison. Through this holistic advocacy, we have seen great changes in our clients' lives. We're on the front line of efforts to dismantle the pipeline through our representation of marginalized communities. We have seen some success in our individual cases, but this moment is a pivotal one in which to recognize, address, and invest in solving this problem on a systemic level. We are seeing the resurgence of zero-tolerance policies and calls for more police in the schools. These measures will only serve to embolden the pipeline and threaten to undo much of the work around restorative justice that we have supported and encouraged. Although there is always more work to do, we highlight today some of our successes. So much of this work would not have been possible without the consistent investment in judiciary civil legal services funding since 2011. Investing in legal services is a long-term investment in the fight against racism, injustice, and poverty. And so on behalf of the Legal Aid Society, I thank you for your continued support and again for the invitation to share a part of our work with you here today.
Thank you very much, Ms. Holder. I've worked with you and your colleagues at Legal Aid for a number of years now, and of course I've heard the phrase school-to-prison pipeline before, but Kamari's story really brought home the dangers of that dynamic very, very vividly for me. So I appreciate you bringing him here to talk with us today. And it was shocking to me that Kamari's only challenge was that he was different than the other students. And that seemed to be more than the school he was in was willing to handle. So I just reiterate how lucky it was that Kamari found you and that you, Legal Aid, were there for Kamari. So I appreciate it.
I think it's wonderful to note that his mother found the Legal Aid Society, and I think it's just so wonderful that she really dug deep. She understood at that point with the school suspension hearing that could easily cascade into even other things. Kamari has shared with us about the Department of Education and some of the things that they had promised or things that they would do, and they just didn't. And I'm so glad that we were able to have an advocate available to he and his mother sought out. I also appreciate the fact Kamari is so mature. I mean, he shared with our attorneys Wilma Marie, that when he reflected on it, and I know I had shared this with other folks on the permanent commission on access to justice, but, you know, he reflected on the fact that he understood that even those who were bullying him, who were committing all these bad acts against him, that they too were actually suffering. And how mature for a young person such as Tamari to understand that, you know, sometimes those bad acts come from the fact that people themselves are hurting and they're insecure. And I really appreciate that about him and so many of his other attributes that really make him such a mature.
That is incredibly mature of him. That's very sophisticated thinking, and it's something I've been working on myself lately. Anything from Ms. Holden? Well,
No, I have nothing else.
There being no questions from the panel, I'm going to let the two of you go, and I'm going to conclude our 2022 public hearings on civil legal services. I want to thank both of you and all our other presenters for their informative and insightful presentations. I especially want to thank those 6 clients who came before us for their courage in sharing their stories with us. And by sharing their experience with us, we are reminded of the truly life-affirming consequences of access to legal assistance. And we found all your presentations to be extremely moving and instructive. I also want to thank my fellow panelists for their attentive participation and their excellent feedback and their strong commitment to expanding civil legal services in New York. And finally, I want to thank everyone who viewed today's live stream for your interest in today's proceedings and for all that you do on a daily basis to serve the legal needs of low-income New Yorkers. Thank you, and we are adjourned.